Good morning. The Senate Judiciary and Public Safety Committee will come to order. Today is March 24, 2023, and we're going to start with Senate File 2909. And since this bill and the next bill, which will be Senate File 2238, are chief author of both, I'm going to ask Senator Westland to take the gavel as we proceed with these two bills.
Thank you very much, Senator Latz. We are going to hear Senate File 2909, and I understand that that is going to be laid over. So, Senator Latz, go ahead and proceed with your presentation.
Thank you, Madam Chair and members of the committee. Senate File 2909 is the governor's proposals within the jurisdiction of this committee. So you can see the bill is kind of thick. I'm not going to walk through the entire bill. The proposal has been out in the public for some time now, so ample opportunity for people to take a look at it. It's got governor's funding for a variety of things and policies that are affiliated with that funding. So we do have commissioners and agency staff available to either make some remarks or answer questions, but I'm prepared just to go forward with the testifier.
Thank you, Senator Latz. And we would like to call Todd Rather up to testify. Thank you, Mr. Rather. If you could take your seat, make sure to identify yourself for the record and proceed with your testimony. And I believe we have a sign-in sheet there for witnesses as well, or maybe we don't. If we don't, we'll find one.
We need a sheet.
Great. Thank you. Go ahead and identify yourself for the record and then proceed. Thank you.
Thank you. This is my first time testifying in Minnesota, so you'll have to forgive my lack of understanding of every bit of protocol, but is there a time limit?
Around 2 minutes.
Okay, I can do 2 minutes. Madam Chair, members of the committee, my name is Todd Rathner, and I represent the Firearms Policy Coalition. FPC is a nonprofit organization that exists to create a world of maximal human liberty, defend constitutionally protected rights, and advance individual liberty. Despite our understanding that some of the offensive restrictions on the people's rights have been removed from consideration for today, FPC remains steadfast in opposition to Senate File 2909. Some of the most egregious provisions still remain. For instance, the extreme risk protection orders remain in the bill and empower government officials to deprive individuals of their right to keep and bear arms and property under unconstitutional factors and standards. The whole star chamber concept that future crime can be predicted and prevented is absurd on its face and offers no assessment, evaluation, follow-up, intervention, or treatment for the subject of an ERPO, implying the subject is not actually an extreme risk. Secret ex parte hearings and surprise seizure of firearms may serve to discourage gun owners from seeking counseling or other therapeutic care. If the government does not have enough evidence to investigate or charge a person with a crime or hold them for a mental health evaluation, then the government has not met its burden for stripping rights and taking property under any scheme. The other provision that remains is the so-called universal background check and the private record keeping that comes with it. Giving law enforcement the authority to delay or deny a permit to purchase to a person who is otherwise not prohibited is unconscionable, as is compelling peaceable people to maintain private registries on behalf of the state for decades, subject to surprise warrantless searches for those same papers and effects so clearly protected in the Bill of Rights. FPC's opinion remains that these sections of SF 2909 should be rejected wholesale, as they are an authoritarian attack on the people you were elected to serve and unconstitutionally limits the right to freely access, possess, carry, and dispose of protected arms. Short of that, we urge your no vote. Thank you, and I'm happy to answer any questions.
Thank you for your testimony, Mr. Rather, and you can go ahead and take your seat, and then if anyone does have questions, because we have a lot to go through on this bill potentially, so, but be sure to sign in on the sign-in sheet.
Thank you, Madam Chair and members of the committee.
Thank you.
I'll give you my card.
And then I understand we'll call up Commissioner Schnell. Good morning, Commissioner.
Good morning, Madam Chair, members. We had a chance to walk through much of this presentation of the governor's budget. We would simply stand for any questions that the committee may have when that time arises.
Thank you, Commissioner. Good morning, Senator Limmer. Any other comments, Senator Latz, or any questions from the committee?
Madam Chair, I'll just note, as Commissioner Schnell did and other agencies, they've already gone through their budgets in front of this committee earlier this session. And although there were some modifications in the governor's latest rollout, those have been made public as well, and folks are well aware of them. These are the governor's proposals. We will take them seriously, and we'll respect, the proposals as much as we possibly can, as we are fitting our budget into the constraints that we have given our targets and the other initiatives out of this committee and the other demands on our portion of the budget. So really appreciate all the work that went into this. And at this time, I would just ask that the chair lay over Senate File 2909 for possible inclusion in an omnibus budget bill.
Thank you, Senator Latz, and this is going to be our vehicle bill for the budget. So seeing no further discussion, we will lay this bill over. Next, we will take up Senate File 2238. Senator Latz, if you could give us some information on this bill. And
thank you, Madam Chair. I am in some ways kind of uniquely positioned with regard to this bill because it funds law clerks specifically for judges. And I say uniquely positioned only because there are not many of us in the legislature that are regularly in the courtroom. We all bring our own valuable perspectives to this job. One of mine is that I'm interacting on a regular basis with the court system, primarily at the district court level. And I see the work regularly that our law clerks do, and I see how substantially our judges rely on the law clerks in order to accomplish what the judges need to accomplish, not only to be prepared for hearings and to understand and be familiar with the cases and the law that are coming before them on civil hearings when they have more advanced notice of what some of the cases are, but also on the criminal cases. And then whenever there are motions and the judges are expected to make a decision and write decisions, the law clerks are usually the ones that take the first crack at the draft and do a lot of the bottom line legal research. Unfortunately, the salary scale for law clerks has gotten so out of whack with other opportunities for them that we're having a hard time keeping them in the judicial system. Hence, this bill before you is intended to provide some financial means by which the law clerks could at least stay and could attract more applicants to these positions as well. One other thing before I turn over to the testifiers. Law clerk is an ancient term, but it's a misnomer. They're not clerks in the sense that we would normally think of as clerks. They are lawyers. They have graduated from law school. They are, if often this is their first job, they're in the process when they start studying for the bar exam, or they start their law clerk job shortly after. While they're waiting for results for the bar exam, They are lawyers who are in the judicial branch working for the judges. So we're never going to change the name. U.S. Supreme Court still calls them law clerks too, and that's just embedded in the system. But I encourage you to think a little more broadly about the work that they do, the value they bring to the system, and that's what brings us here today. Thank you.
Thank you, Senator Latz. Judge Brown, thank you for joining us today. Please state your name and your position for the record, and we'll have a sign-in sheet there for you as well.
Well, Madam Chair and members of the committee, thank you so much for having us here today. I am David Brown. I'm a district court judge here in Ramsey County, which is the 2nd Judicial District. I'm here on behalf of President Lois Conroy of the Minnesota District Judges Association. She was not able to be here today, but the District Judges Association represents approximately 300 district court judges, as well as our appellate court judges and Supreme Court justices. The District Court Judges Association really took this on and wants to thank Senator Latz for sponsoring Senate File 2238. As Senator Latz pointed out, the term is law clerk, but these are staff attorneys. The citizens of Minnesota expect our district courts to take on some of the most serious issues we have: child support, child custody. We've all seen in the news horrific criminal cases that are complex. They raise incredibly complex legal, emotional issues. Our citizens expect us to get those decisions out on time, and as my 8th grade math teacher would have cautioned me, show your work. And the people that do that, the backbone of this system, is really those judicial law clerks. They are helping us make sure that we have well-reasoned and timely decisions. We surveyed our district court judges. 100% of them responded that the law clerks are essential or extremely important to our work. Now, these are staff attorneys. The average public law entry position, starting salary is about $74,000. The starting salary for our judicial law clerks is $57,000. So the purpose of this bill, what we're asking for with this one-time market adjustment, is to try to bring our law clerks closer to that public entry salary. I know time is short, but one of the questions when you do one of these market adjustments that everybody asks is, well, are you having any problem hiring people? And are you having any problem retaining people? The answer to both of those questions is unfortunately and tragically, yes. 93% of the judges we surveyed reported a decline both in the number of applications and in the quality of those applications. To put not too fine a point on it, one of my colleagues on the Ramsey County bench, when he was first appointed, had 140 applications for his law clerk position. That's back in 2012. This year, when he posted that, he had less than 10. Judge in Lyon County in southwest Minnesota went without a law clerk for 6 months because they couldn't get qualified applications. As to retaining law clerks, 85% of our law clerks who were surveyed say they have difficulty making ends meet without a second income. It's a personal story. One of my law clerks who was single, didn't have a second income in the family. She worked at a restaurant on weekends to try and make ends meet. And here's the one that got to me. 9th District, Northwest Minnesota. We had a judge whose law clerk left her employ to go work at the local Cenex gas station because they could make more money. That's just not right. So I understand that even with the surplus, budgets are tight and things are hard, but this is a market adjustment that seems to make some sense. So we are very much asking that as you think about the budget, you'll consider this bill. We had a change in testimony, Madam Chair, and with your permission, our next witness, I believe we had one submit a letter instead of his testimony, and our next witness then would be Ellen Cheetah.
Very good. Thank you so much, Judge Brown. I appreciate your testimony. And please go ahead and state your name for the record, and be sure to sign in on the sign-in sheet.
Thank you. Good morning, Madam Chair. My name is Ellen Cheetah, and I am a judicial law clerk in Hennepin County. I've worked there since 2005, and I've worked in family, criminal, and civil divisions. Position of law clerk is often viewed as temporary, but in Hennepin County, the learning curve is steep, and learning all the requirements of our job, both administrative and legal, often takes more than the expected 1 year of a clerkship. My duties include research and writing initial draft of orders, clerking trials in advance, preparing all motions in advance. Law clerks in Hennepin Civil, we are in charge of the judge's schedule. We schedule all civil hearings, formal and informal. We answer all calls to the judge from lawyers and self-represented litigants, and we have to advise them as to the process without giving legal advice, which alone can be very stressful. We review any new case filings for the judge on a daily basis to see if there's anything immediately necessary. We keep track of those cases in our case tracking system. And in my office, that means there's 2 of us for anywhere between 130 and 170 civil cases at a time. We also handle criminal matters, pleas by mail, things like that. All case continuances, case modifications, sentence modifications, we do that. Running the chambers and managing the administrative tasks has taken up, all of it has increased since the pandemic, and it's taken up a lot of our time, and it leaves less time for our original duties, which is helping the judge draft legal decisions and make the right choices in that respect. We're in charge of all Zoom hearings, which often means we are the only ones in the office because the attorneys don't have to come in and the judge doesn't have to come in, but we do. And I'd like to make it clear that my duties are very different from other law clerks around the state. The duties differ from district to district and from judge to judge, but I think all of us are in unison in saying that we don't get compensated properly for the work that we do in making the judicial system work. So, thank you.
Thank you so much for your testimony. Appreciate that. Are you Ms. Peterson?
Correct.
Great. We have Carrie Peterson. And Ms. Cheetah, when you're done, we'll have Mr. Reynoso come and take your seat. Thank you.
Thank you.
Madam Chair, members of the committee, my name is Carrie Peterson. I've been
Can you
clerking-
pull that microphone right in front of your face?
I
There you
absolutely
go.
can. Is that better? Perfect. My name is Carrie Peterson. I've been clerking for 4.5 years in Duluth and Rochester for 3 different judicial officers. 2 salient points at the moment. Basically, we do not get paid enough for our education level. We don't get paid competitively with other entry-level attorney jobs, and it's not a particularly livable wage, as Judge Brown mentioned. A lot of law clerks do side jobs. For example, I have somewhat inadvertently become the pet sitter for the Duluth courthouse. It's very fun. I left a puppy today. It was very sad. Other salient point, we are vital. As Judge Brown also mentioned, law clerks do a lot of the drafting and other admin works. For example, I work 40 to 50 hours a week, depending on what we have going. Without a law clerk, and we can't keep them, judges are going to be working 80 to 100 hours a week, and you're going to burn out your judges within 2 years. Personal story, my judge, Judge Harris, when he started on the bench 13 years ago, he had 80 applicants for his law clerk position. When I applied 2 years ago, he had 5. Fortunately, I had the experience and I'm good at my job, so he hired me and I'm very lucky to stay. I am one of the fortunate few who doesn't need a second job because I live with family, I don't pay rent. That said, I still have law clerk student loans rather, and just other necessities such as food or gas. I had to buy a new car in 2020, which was not the best time to buy a car. And because of that, my normal costs are still 2/3 of my income, and that is making almost $60,000 a year with the cost of living adjustments over the last 5 years. Just to reiterate, this is not commensurate, it is not a livable wage for us, and we are vital to this system. Thank you.
Thank you, Ms. Peterson. Be sure to sign in on the sheet, if you could. And Mr. Reynoso, will you please identify yourself for the record, and you may proceed with your testimony.
Good morning, Madam Chair, members of the committee. My name is Edward Reynoso, and I serve as the Director of Political and Legislative Affairs for Teamsters Local 320. Our local represents over 10,000 members, including 270 court clerks working in the judicial branch. Today, I am here to express our strong support for Senate File 2238, which proposes a one-time adjustment for district law clerks. The judicial branch is an essential component of our justice system, and it is vital that we attract and retain the best talent possible. Regrettably, the current compensation structure poses significant challenges to both recruitment and retention efforts. A fiscal year 2022 analysis uncovered a concerning 5 to 10% wage gap when compared to other public sector employers, which undermines the judicial branch's ability to attract and retain skilled professionals. This, in turn, jeopardizes the efficiency and effectiveness of our justice system. The absence of a supplemental budget last legislative session has also led to stagnated salaries, exacerbating the existing wage gap. In order to safeguard this crucial pillar of our democracy, it is imperative that we urgently address these compensation disparities. Failure to do so would put overall efficiency and effectiveness of our justice system at risk. We'd like to extend our gratitude to Chair Latz for introducing this vital legislation and encourage its inclusion into the omnibus bill. By doing so, we can help close the compensation gap and enhance the judicial branch's ability to secure the skilled professionals necessary for maintaining a robust and effective justice system. Thank you for the opportunity to convey our support.
Thank you, Mr. Reynoso. Be sure to sign in on the sheet. Okay, great. Senator Latz, well, actually, I guess we'll open it up. Does anyone have questions or comments on this particular bill? Senator Kroon.
Thank you, Madam Chair. I'm a former law clerk, so I'm very familiar with what law clerks do. It's a fantastic job. I got a couple questions. And I'm confused by the last testifier. Did law clerks become unionized at some point? Did I miss the memo on that?
Mr. Reynoso, Senator Latz, Mr. Reynoso, either one of you want to address that question?
Thank you, Madam Chair. Senator, we represent 270 court clerks in the state of Minnesota.
Senator Kroon.
No.
You represent 207 unionized law clerks?
Yes.
And are
Senator
there,
Kroon.
thank you, Madam Chair. Are there non-union law clerks still?
Mr. Reynoso.
Madam Chair, Senator, I'm not aware of that. I'm not aware if there's any law clerks that aren't unionized.
Senator Kroon.
Madam Chair, thanks. And forgive my ignorance on this. I didn't just for my own edification, when did law clerks become unionized?
I don't.
Mr. Reynoso.
Madam Chair, I apologize. I do not know of the year that they were organized.
Okay. Well,
Senator Kroon.
Thank you, Madam Chair. That's news to me. It makes me think differently about this bill. I'm going to get my next question, and then whoever wants to answer either of the questions
You can,
is fine with me.
excuse me one moment. Ms. Cheetah, go ahead and take a seat. If you can answer questions, we'll allow that. Senator Kroon.
Thank you, Madam Chair. When I started law clerking, the pay was $26,000 a year. And for me personally, I viewed the job as experience to get some real life experience in the court system, watching litigators, wanting to become a litigator. And the pay was secondary to me, although I do admit $26,000 was awfully low, for somebody just starting out with student loan debt. So I do have some sympathy for if the pay has again gotten to the point where we're not getting applicants. And I guess that's kind of the primary concern is, are we getting the quality applicants? And it sounds like the answer to that is no. But I also, on the other hand, do have a concern that I saw when I was clerking starting to creep in, and I don't know where we're at with that, where the law clerk position is becoming more of a career position, and I do not think that is the purpose of the law clerk position. And to learn that it's been unionized is a little troubling to me, because I don't view this as a career position. I view this as a temporary position to gain experience while making a good living, and I'm not unsympathetic to the pay concerns, and we want to have quality applications. But will this bill do anything to encourage judges to keep their law clerks for more than a year or two, which I think is the proper amount of time they should be in that position?
Mr. Reynoso, would you like to respond
Madam Chair,
briefly, please?
Very briefly, I apologize for my mistake. We actually represent the court clerks, not the law clerks.
Senator
Chair,
Kroon.
Thank you. Thank you for that clarification. And disregard everything I've said the last few minutes.
Your comments shall be stricken from the record.
Thank you, Madam Chair. Appreciate it.
As my comments, Madam Chair.
All right.
As yours.
Okay, I appreciate that clarification. So I do think that we need to get the law clerk salaries up to being competitive so that we have ample applications for the judges so that they can get quality applicants. And my comment, though, on the second part does still stand. I don't want to see this position turn into a career position. I don't think that's healthy for the system. And it would actually limit opportunities for law school graduates coming out of law school to have those positions, to gain that experience. So I support an increase in pay with that caveat. Thank you, Madam Chair.
Go ahead, Ms. Cheetah.
Thank you. I would just, Mr. Reynoso has made the clarification, and it's my understanding that the administrative clerks, the court clerks are unionized. The law clerks are not. That said, I would also point out that there have been, as in industries across the board, staffing issues even with the district court clerks, meaning that the law clerks have had to take on significant administrative duties not ordinarily assumed by law clerks. So we've been doing parts of both jobs for years now, and that means that there's a whole lot more to learn. There's a higher learning curve, learning all of the processes as opposed to just assisting with the legal processes. And so learning that takes longer than even a temporary position allows, at least in Hennepin.
Senator Limmer.
Thank you, Madam Chair. Good morning. I had a quick question, not so much on the pay, but on the process that we're experiencing. We have this appears as though this is a request from the Minnesota District Judges Association. And usually when there's discussion about salaries and employee benefits in the third branch of government, we get the request from the Judicial Council, which represents the administrative function of the judiciary. So I don't see them in the room. I don't see them coming to the testifying table. So, Senator Latz, could you give me an indication of whether or not the Judicial Council supports this provision or not?
Senator Latz.
Madam Chair, Senator Limmer, you are correct that the courts don't itemize their specific types of employees in terms of their budget requests. They came in with a request for a 9% increase in the first year, 6% in the second year for all the judicial salaries. This is an independent proposal by the District Court Judges Association. It has not been, it is not concurred with by the Judicial Council or the Chief Justice specifically. They would prefer, as I'm informed, that they have, that we act on their broad request for maintaining services with the 9% and the 6% increases, and that they have the unfettered discretion to decide how to distribute those funds within the branch. There is a little bit of a separation of powers issue here, as I understand it, and it seems to me there may be an argument that the judicial branch could take whatever we suggest or put in statute as a suggestion rather than a mandate because of that separation of powers issue. But I firmly believe that it's worth identifying this particular line item for its necessity and its potency. I can tell you it's not a matter of the judges deciding they want to keep clerks longer than 1 year. It's a matter of the clerks deciding to leave for greener pastures or not applying in the first place. The fact is, it is turning into careers or at least longer-term positions. It's not just for some years' worth of experience and credentialing before they move on somewhere else. So I've answered two questions at once there, Senator Limmer and Senator Kroon.
Okay. Madam Chair.
Senator Limmer.
I know that the legal field seems, at least in the Twin Cities area, it seems to be a very crowded field. We have a number of very good law schools that keep cranking them out, and I scratch my head to determine whether or not there's a big enough pie out there for everyone to get a slice of. But nevertheless, I do know that, at least in the past, clerkships were a temporary position giving experience, unique experience to certain candidates, well qualified as they are. The only thing I would say, just like in the private sector, the public sector, there is no guarantee for long-term tenure. And I've always recognized that. That is a market condition as well. And so as I just wanted to mention that because I'm hoping that as we look over budgets, and at this time, it's kind of a land of plenty with a surplus, and with budget proposals going through the roof, there might be lots of opportunity for people to get jobs and keep jobs for a long time, but those days will change. And just like in the private sector, there's no guarantee for a life estate at a job. Thank you.
Any other questions or comments? All right, this bill is going to be laid over for possible inclusion in the omnibus bill, and I shall gladly return the gavel to Chair Latz.
Good to see you. Great to see you.
If Senator Klein is still around, you can come forward. We're going to take up Senate File 803. All right, Senator Klein appears to have vacated the premises, so we'll go on to Senator Boldon's bill, Senate File 2673. Come on forward, Senator Boldon. Go ahead, Senator Boldon, tell us about your bill.
Thank you, Mr. Chair and committee members. I am pleased to be before you this morning with Senate File 2673. Medical debt is a widespread problem that can be financially devastating for families. Over 750,000 Minnesotans had medical bills in collections in 2018. This is equal to 17% of Minnesota adults. And this impact isn't just financial. Some people delay necessary medical care for fear of taking on more debt, and in other cases, hospitals have been known to deny care based on unpaid debt. In some cases, patients are eligible for financial assistance at the time they receive care, but they aren't aware of it or aren't able to complete the process to qualify for assistance. Because assistance programs have limited look-back periods, by the time people reach out for help with a debt, it's often too late for them to qualify for that assistance. Senate File 2673 addresses this problem by establishing requirements for hospitals to screen patients for eligibility for both health care coverage and financial assistance. The bill basically does three things. The first, for uninsured patients, the bill requires hospitals to screen them for likely eligibility or charity care, public health care coverage, or premium tax cuts, and assist patients with applying for assistance or referring them to a navigator or other support. Secondly, it requires hospitals to determine whether a patient is eligible for financial assistance prior to taking certain actions to collect that debt, such as referring the debt to a third-party debt collector, pursuing wage garnishment, or pursuing litigation. And thirdly, it requires hospitals to certify that they have complied with all provisions required by the Attorney General agreement related to debt collection prior to referring a patient account for collections. I'll just say, members, I see this every day in my clinical practice as a nurse, that medical debt weighs heavily on Minnesotans, and it does impact their ability to get, to receive and seek out care. And so this bill is an attempt to just get patients information so they can get the assistance that they qualify for. I'll note that we have been in conversation with many stakeholders throughout this process, including the Minnesota Hospital Association, the Navigator Coalition, Lutheran Social Service Financial Counseling, and United Community Action Partnership. And I want to thank the Attorney General's Office, MNsure, DHS, Senate Council, and the Asset Building Coalition for their assistance with this bill. And when it is appropriate, Mr. Chair, I do have an amendment as well.
Members, the A3 amendment is in the folder. This is not the first stop for the bill, so it was not an author's amendment. Senator Limmer.
Before we get too deep into this, what is the jurisdiction on this bill for our committee?
Ms. Primo.
Mr. Chair and members, it's mostly section 2, which requires a certification of expert review that the hospital must provide before sending, before beginning a collection action or sending it to a third party. It's possible some of the definitions in section 1 might be appropriate for the committee to also take a look at.
Senator Boldon, why don't we go ahead and take care of the amendment first. The A3 amendment, as I understand it, is the first part of it anyway is mostly technical changes, but maybe you can just give us a brief description. The second part of the amendment at the bottom on collection agency is directly within this committee's jurisdiction either way. So.
Yes, Mr. Chair, happy to do that. This amendment is the result of ongoing conversations and some concerns that were brought up in our previous hearing. It is meant to address those. And so the first part, as you noted, is largely technical, really getting to be clear on the intent of the bill, that it is not to delay discharge from the hospital by taking these actions. And so we want to be clear about that we are not aiming to delay anyone's discharge. There's another piece that changes some language that was ableist, just to be transparent, and so cleaning up that language, not substantively changing anything there. And then the last piece is around making it clear that it is the hospital's responsibility to take these actions, and clarifying that from a third-party debt collection agency. And lastly, that this is forward-looking and does not apply to previous debts or actions before enactment of this bill.
So a few changes to the effective date language then at the end. All right, are there any questions from members of the committee about the A3 amendment? All right, Senator Pappas moves that the A3 amendment be adopted in the Senate File 2673. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. All right, why don't we hear from the testifiers? I have Yolanda Pearson as the first person on our list. She is appearing virtually, I understand. Is Ms. Pearson here?
Yes, I am.
You're here in person?
Yes.
A lot of people are in person now.
Wonderful. Welcome to the Judiciary Committee. Go ahead and introduce yourself and proceed with your testimony.
Good morning, Mr. Chair and members of the committee. My name is Yolanda Pearson. I live in Blaine, Minnesota with my husband, Waylon Sr., and our 4 children. Our youngest son, Waylon Jr., who is now 11, was diagnosed with Coates disease in his right eye when he was 5 years old. Coates disease is caused by a problem with the arteries and veins in the blood vessels inside the back of the eye that provide blood and oxygen to his retina. After treatments at several local clinics, he was referred to a hospital for an anthropology specialist. Waylon has undergone 8 surgeries and had over 21 office visits, many of which were billed as outpatient surgeries because of his age and the process needed to check the back of his eye for each visit. Our insurance typically had most of these under our deductible coinsurance, in which they pay 60% and we pay 40%. We reviewed the explanation of benefits with our insurance company several times to understand the cost breakdowns and why these were billed as surgeries. Our costs kept increasing the more visits we had with the hospital, along with transportation and missed work that we needed to care for Waylon. On many occasions, my husband wasn't even able to attend because one of us needed to be at work and or with the other children. At the time of the surgeries, we were making small monthly payments. In 2020, we did not make any payments. In 2021, we were told that Waylon couldn't be seen at the hospital because we had outstanding bills. We were advised that we needed to pay the balance from previous years, $2,056.17, to be placed on a payment plan. We were never verbally told that we could apply for financial assistance. We were told about Minnesota Care, which we didn't qualify because we already had private health insurance. When I called the hospital, they would transfer me directly to the collection agency. No one from the hospital will speak to you once you have been placed with collections. At this time, we utilized a credit card to pay the bill so that Waylon could be seen at the clinic to continue care for his eye. We discussed this with the doctor, who had no idea of what was going on. A few months later, we were sent a demand letter from the collection agency for the remaining balance. Then a month later, we were sued by the collection agency and issued a bank garnishment on behalf of the hospital for $3,163. At this time, to prevent further actions, a judgment, or a lien on our house, we used another credit card to pay the bill. Then the collection agency advised us that we still had an outstanding balance that would be sent over in a few weeks for an additional $2,087. In total, we paid $7,300 on our credit cards to continue having Waylon's care be taken care of. We're still paying that credit card debt today. In recent months, we found out that there were funds available via financial assistance that we could have qualified for at the time of the bulk of his procedures. That's disheartening as a parent. We focused on saving our son's eye and didn't fully understand the assistance that was available to us, and no one at the clinic explained that to us, either myself or my husband. Today, our son Waylon has 20% light sensitivity in that eye and no other vision. He will continue to need care for the rest of his life to ensure that his eye is protected and detect any early signs of changes. Thank you for allowing me to testify today in support of this bill so that no other families have to experience what we've had to face.
Thank you, Ms. Pearson. Appreciate you being here today.
Thank you.
I have Kim Miller on the list. Are you Kim Miller?
Yes.
Also not appearing virtually. Welcome to the committee. Go ahead and introduce yourself and your affiliation and proceed.
Thank you, Mr. Chair, members of the committee. My name is Kim Miller, and I'm a certified financial counselor with Lutheran Social Service of Minnesota. LSS Financial Counseling has over 30 years of experience supporting thousands of people in Minnesota and nationwide. We have offices in Brainerd, Duluth, Virginia, Wilmer, St. Cloud, Mankato, Minneapolis, and St. Paul, and I've also partnered with LSS Youth Services in Rochester. I am here in support of Senate File 2673, aimed to screen patients for public health care coverage and other financial assistance prior to proceeding with payment plans, debt collection, denial of care, or credit product. In my work, I see how medical bills affect our clients' finances on a regular basis. Attempts to make payments on unaffordable medical bills can create crises that lead to an overall destabilization of their financial situation. Assisting eligible patients with enrollment of public health care programs or discounted care helps families avoid the financial stress of medical debt that would otherwise have been covered by programs or assistance. My job includes working with people directly, as well as providing financial train-the-trainer workshops to frontline workers who support low-income families. A common barrier I hear is filling out and managing paperwork. There are barriers with language, reading and writing, as well as overall capacity to manage documents. In stressful times, especially with medical needs, extra support makes it possible to complete the screening process. Medical assistance programs can backdate bills up to 3 months, so doing this in a timely manner is helpful in reducing medical debt. For example, I had a client with a $600 medical bill that would have been covered by our hospital's financial assistance program, including an affordable repayment plan by the client, but the deadline had passed to apply, and then her situation that led to this medical treatment directly contributed to her being unable to complete the application. As a result, the bill went to collections and the hospital did not receive any payment. Another barrier is asking for help. It's really hard to do. Offering screening assistance directly as part of the process reduces the stigma and feelings of shame that may stop someone from accessing resources available to them. Shame affects people of all income levels, and I have heard the relief in people's voice when they tell me, "Thanks for not judging me and providing options instead." Informing patients they qualify for assistance programs and normalizing the use of them right away can increase access to health care and reduce the burden of medical debt. Thank you for your time.
Thank you for your testimony, Ms. Miller. We'll invite Judy Cook and Mary Krinke to come forward to the testifier seats. Ms. Cook is waving us off. All right. And Bennett Hartz, if you're here, you can also come forward to testify. Ms. Krinke, go ahead and identify yourself and present your testimony.
Chair Latz and members of the committee, for the record, my name is Mary Krinke, and I'm with the Minnesota Hospital Association. Prior to last week, the hospital associations had signed off on this bill. We've been working with the advocates over the last year. This bill was introduced last year. And as Senator Boldon said today, we support 2 of the provisions that she outlined. We want to be able to screen individuals to see if they're eligible for Medicaid or Minnesota Care, and we get them enrolled in our public programs. We serve an important role in doing that. We also recognize the need to share our charity care policies with individuals who come into the hospital. So those are 2 of the provisions that were in the original 2673 bill, and we were willing to support that bill. Last week in committee, there was an amendment that was added that would add the Attorney General's agreement to this legislation. I just want to remind everyone what the Attorney General's agreement is. It's an agreement that every hospital in the state of Minnesota has with the Attorney General. It's been in place since 2005. It was renewed in 2021 and is in effect until 2027. So all of our hospitals have signed an agreement with the Attorney General that is in effect till 2027. The current Attorney General's agreement aligns with the federal No Surprise Billing Act. So there's no conflict between our AG agreement and the National No Surprise Billing Act. The Attorney General's agreement has some differences with what they've added to this bill. And so there are some differences with the current Attorney General's agreement and some of the language that was added last Friday to this bill. We have some concerns because now the new bill says that the Attorney General will have the authority to review the first part of this bill, which is everything to do with screening and our navigators and setting up appointments. Please understand that the Attorney General's agreement was about collecting medical debt, standards for third-party collections, and billing of uninsured patients. getting the Attorney General's authority over whether or not we've been able to schedule an appointment with a navigator and some of the nuances of getting people enrolled in our public programs is a little bit more in the minutia of what is not included at all in our Attorney General's agreement. So the amendment that was added last Friday causes us concern because it's not in alignment with our original Attorney General agreement. So we liked the bill before last week better than we do now. So thank you for consideration of those comments. Mr. Chairman, if I
Ms.
can,
Krinky, I'm sorry, could you tell us what page and line number that
Yes.
you're referring to?
Yes, the line that we are concerned about is 4.10. It's the enforcement section, 4.10, 4.11, that gives the Attorney General authority to enforce the earlier sections of the bill.
And this was added in HHS?
Last Friday.
Last Friday. All right, did you have anything further to testify to, Ms. Krinky? Ms. Krinky, did you have anything else you wanted to say as part of your initial remarks, or shall we go to some questions about this concern you've raised?
Mr. Chairman, I just would like to close by saying we know that right now there are 1.5 million Minnesotans that are potentially going to lose their health care coverage if we don't get them enrolled in Minnesota Care and MA with the unwinding of the federal public health emergency. We know hospitals have an important role in helping to enroll people in our public programs. There are good things in this bill, and that was the original 2763, helping people enroll in our public programs. We really would like to keep the Attorney General's agreement separate. It's in place until 2027. Nothing's going to change with the Attorney General's agreement until certainly, at least not until after 2027. So thank you.
Thank you, Ms. Krinky. Members, this provision is, maybe, Ms. Krinky, before you go, I'm sorry, while you're here, I'll just ask you this question now. There are other places in the bill where there is this identical provision. You've only identified it in one section of the bill. Are you concerned about them in the other sections of the bill as well, or is it just the one you identified?
I believe we are concerned about the provision as it is in multiple places.
Okay, so members, I'll call your attention then for your assistance. Line 5.29 has the Attorney General enforcement provision in it, and line 6.10 does as well. Were all three of those provisions added in HHS last time?
Yes, Mr. Chair.
All right. Well, let's hear from Mr. Hartz from the Attorney General's office, and then we'll ask the Chief Author for thoughts on this particular provision. Mr. Hartz, welcome to the committee. Go ahead and identify yourself.
Thank you, Chair Latz, Senators. My name is Bennett Hartz. I am an Assistant Attorney General in our office's Consumer Protection Division. The Attorney General has asked me to share his strong support for Senate File 2673, which builds on the protections provided in what the hospitals call the Attorney General Agreement and what we call the Hospital Agreement at the Attorney General. The Hospital Agreement was first signed in 2005 after the Attorney General, then Mike Hatch, discovered at least one hospital's downright disturbing collection practices. For example, the hospital was sending process servers to serve people with collection lawsuits for medical bills while they were still admitted for care. The hospital agreement requires hospitals across the state to respect their charitable missions when they collect their bills. Senate File 2673 codifies and builds on these protections. Now, affordable health care is essential for Minnesotans to be able to afford their lives and live with dignity, safety, and respect. The Attorney General wholeheartedly supports these patient protections and feels that they're both consistent with the hospital's existing obligations under the hospital agreement and with their charitable missions as nonprofits. For these reasons, Attorney General Ellison strongly supports this file and urges the committee to support its passage. Thank you.
Mr. Hartz, can you address the point raised by Ms. Krinke, the provisions that were added for enforcement under Section 8.31 in 3 different parts of the bill? What is the Attorney General's office position on that?
Chair Latz, it's a question of efficient use of public resources for us. The Attorney General has very broad power to investigate and stop unlawful practices in business, commerce, and trade already under Minnesota Statute Section 8.31. And that statute already empowers our office to enforce these provisions, regardless of whether there's an explicit provision regarding our enforcement capacity in the statute. However, in practice, even though the Attorney General's scope of authority is clear here, when a statute does not specifically state that the Attorney General has the ability to enforce it, we occasionally have parties litigate this issue. And even though it's not an issue that we ever lose, in practice, fighting these motions to dismiss, motions for summary judgment require public tax dollars, public money, defending against motions that really lack merit. So making the Attorney General's authority here explicit streamlines our office's ability to enforce what we would already have the capacity to enforce under 8.31.
Mr. Hartz, does it in any way conflict with what you call the hospital agreement, what hospitals call the Attorney General agreement?
No, I don't think that it does. Chair Latz, the hospital agreement is a private agreement between the Attorney General's office and nonprofit hospitals across the state that we can already enforce as a party to the agreement. This statute would come in under a different enforcement mechanism. That would be statutes 8.31 and then the specific language of the provision discussed today, but those two things wouldn't be in conflict with each other.
Thank you, Mr. Hartz.
Thank you.
Any questions while Mr. Hartz is at the table or Ms. Krinke is close by for either of them? Senator Kroon.
Thank you, Mr. Chair. I'd be interested in learning more about whether or not the language under this bill does actually conflict with the existing AG agreement. I understand that you can say, well, that's a private agreement and this statute would come in under different enforcement mechanisms, but that doesn't really answer the question about whether they're substantively in conflict. And I would be very concerned if that's the case, if there is this private agreement that runs through 2027, it seems to me that is what should be honored, and that should be the agreement at least through 2027.
Mr. Hartz.
Senator Chair Latz, Senator Klein, that's a very good thing to be focused on. Our intention at the Attorney General's office is not for this bill to put hospitals in a position where they're caught between, on one hand, complying with a voluntary agreement with the Attorney General's office, and on the other hand, complying with statute. So if there are any provisions in this bill that create that double bind where a hospital couldn't comply with both, we would want to know about that and discuss it, because that is not the intention of our support for this bill.
Senator Kroon.
Thank you, Mr. Chair. Well, I guess I'm at a bit of a disadvantage because I don't have the agreement in front of me, and I can't do that kind of comparative analysis. I don't know if Ms. Krinke can point to any specific items that would conflict, but it seems like those things should be worked out before we get to a final version of this bill.
I'm going to ask Chief Author Boldon for input here, and we'll invite Ms. Krinke to come in and weigh in if she has anything to add as well. Senator Boldon.
Thank you, Mr. Chair, and I appreciate this discussion. The intention of this bill and the language of this bill is not to be in conflict with the agreement. It is to be in alignment with the agreement, whether you call it the AG agreement or the hospital agreement. It as was explained well by Mr. Hartz, to just be explicit about that agreement and that ability to enforce, and so it is not in conflict with the current agreement.
Ms. Krinke.
Chairman Latz and members of the committee, I just feel I really need to clarify a couple things. Number one, it is a public agreement. It is on the website of the Attorney General. So in all of our Minnesota hospitals have signed the agreement, and it is a public agreement. So you can look at the terms of that agreement. There are some differences between what's in the bill and the Attorney General's agreement. And I would say that the Attorney General's agreement is focused on collecting medical debt, standards for third-party collection, and billing of the uninsured. This bill has scheduling appointments with navigators. This bill has how we set people up and get them enrolled in Medicaid. It's very different than what's in the Attorney General's agreement. So,
Ms. Krinke, I'm sorry to interrupt you.
Yeah.
But those decisions, whether to pass the bill substantively for those purposes, I think was really HHS's decision. And what brings the bill before us are primarily Section 2 relating to collecting of the debt and penalties for noncompliance and so on. Now, the Section 8.31 enforcement provision, I would say, is also within this committee's jurisdiction, but if you could focus your attention, please. I don't think it's appropriate for this committee to start getting into fly-specking the differences between this agreement and the bill in front of us.
Okay.
Unless someone else has a different opinion on that, that'd be the way I'd look at it. But I think we do have a role to play in determining, to the extent we have the information to do so, whether or not the language in Section 8. The language in the enforcement provisions here conflicts with that agreement. So do you have a position on whether or not the addition of the Attorney General's explicit authority under 8.31 in this bill in the 3 different locations, whether that itself conflicts with the terms of this Attorney General hospital agreement?
The Attorney General's agreement aligns with the Federal No Surprise Billing Act. The Attorney General's agreement is revolving around those 3 key things, and now the Attorney General would be given the authority to oversee all the other provisions in the bill that are not part of the Attorney General's agreement. So they are adding new requirements and treating it like they are part of the Attorney General's agreement when they are not.
Are you suggesting, Ms. Krinke, that the Attorney General does not have the authority to enforce those provisions under current law?
No, sir, Mr. Chair. The Attorney General, I think, can enforce a lot of things on nonprofit hospitals. I'm saying that the bill, as it was originally introduced, was trying to get at the problem of should hospitals be more upfront with their charity care policies, and the story that Ms. Pearson shared with us today would be addressed by the passage of this bill as it was originally introduced without the Attorney General language, because the hospital would have been required to be more upfront with its charity care policy. So I am making the case that the AG's agreement does not need to be added to this bill, that they're separate ideas. So I think I'm answering your question, yes.
Ms. Krinky, I'm not understanding you to be answering the question directly, so let me try to be a little more clear. The language that was apparently added says, in addition to the enforcement of this section by the Commissioner, the Attorney General may enforce this section under Section 8.31. And that is identical language found in 3 places in the bill, at the end of each section of the bill. The Attorney General's office testifier, Mr. Hartz, is stating that that merely codifies enforcement authority that the Attorney General already has under existing law. Is that a position that the Hospital Association agrees with or disagrees with?
Mr. Chairman, we don't think that that language is needed in dealing with the original bill. I don't know if I'm questioning the attorney. I don't know that I'm questioning the Attorney General's authority. I'm just saying it's not part of what the agreement with the Attorney General is, and it was not part of the original bill.
All right, thank you, Ms. Krinky. Any other questions or discussion from members of the committee? Senator Boldon, any final thoughts before we decide what to do here?
Thank you, Mr. Chair and committee members, for the discussion. Just to sort of close the loop on the enforcement piece, I think, just to reiterate, this is an ability the Office of the Attorney General already has. This language is just making it explicit and clear. And overall, I would just say that this is a significant issue for many Minnesotans. The issue of medical debt is a weight around the neck of too many Minnesotans, and we have an opportunity here to just provide information to folks to make that a little better for some folks in our communities, and I think that is what we should do. So thank you for your consideration.
Thank you, Senator Boldon. I will note, when I first came into the legislature, there was a big expose in the media. It might have been resulting from then Attorney General Hatch's efforts dealing with charity care and hospitals, and I carried a bill. I can't even tell you the details of it any longer. That required some review of that. I think, was it the Catholic, not Catholic Charities, a Catholic Health Association or something like that had some, the national organization had some detailed guidelines on how hospitals ought to handle charity care questions. So this issue has been around for a long time. I'm a little dismayed to find out that there are still issues relating to it. I'm glad that the bill has come forward to try to address those. And I, for one, have no problem codifying the Attorney General's authority to enforce it if it is in doubt in any way. They are the appropriate place for that authority to enforce it, to lie. With that said, Senator Umu Verbatim moves that Senate File 2673 as amended be recommended to pass and be re-referred to the Senate Committee on Health and Human Services. All those in favor say aye. Aye. Opposed? Motion prevails. Thank you, Senator Boldon.
Thank you.
Senator Klein, Senate File 803.
This is an author's amendment. It was referred to different committees. They didn't need it, so it came in.
Senator Klein, welcome to the Judiciary Committee. We have Senate File 803 before us. Why don't you tell us what the bill does, and we'll take it from there.
Chair Latz and committee, and my apologies for not being present when you called me earlier. So this is Senate File 803.
There will be a price to pay, Senator Klein.
I suspect there will be. Senate File 803 is the Candor legislation. I'm extremely pleased that this is getting a hearing before Judiciary this year and that it has agreement from the various parties to move it forward. So many times following an adverse event or bad outcome at a healthcare facility, providers are advised not to say anything to the injured party because of a fear of a lawsuit. And because of that, we hear from patients and their families that they never hear anything about what happened, and then they feel they need to file a lawsuit to get that information. and often they never do find out, even if a lawsuit is filed. Senate File 803 provides a voluntary alternative to filing a lawsuit following an adverse event at a hospital or clinic. This process is only in cases where both parties agree to participate in the Candor process. The Candor process, which stands for Communication and Optimal Resolution, was first developed by the Federal Agency for Healthcare Research and Quality as a way to address patient safety. It protects discussions between the provider and the injured party from potential discovery if there is a later lawsuit. That protection is only offered if both sides agree to enter the Candor process and allows either party to end the process at any point to pursue other legal actions. This is needed to encourage conversation between the provider and the injured party to determine what happened and hopefully avoid similar problems in the future. Mr. Chair, this already exists in a handful of other states, Iowa, Colorado, Utah, others, and in those states, resolution has been much faster than litigation, think months instead of years, and rarely has an injured party chosen to pursue litigation once they have started Candor. This does not preclude an injured party from filing a complaint with the Minnesota Board of Medical Practice or from a facility from conducting an investigation. And I have an author's amendment that is the result of discussions between the Minnesota Medical Association and the Minnesota Association for Justice. And with the amendment, I know of no opposition to the bill. Senator Chair Latz, before I move the amendment, I just have one quick anecdote out of tens that I could tell from my career as a physician. There was a case where I was in the hospital emergency room about 5 years ago, and a woman came in and she had been in the hospital a few days previously, and someone had left her IV in her arm, and she didn't question it because she thought people knew what they were doing and it had become infected, and so she was going to get admitted with a skin infection or a cellulitis related to this IV that had been retained in her arm. And I apologized to her. I said, on behalf of the hospital and us as medical practitioners, this was a mistake, and I regret it, and I apologized. And I was pulled aside by hospital administration after that and advised to not do that in the future without sort of legal representation present and so forth. That's just the sort of defensive and caged mentality that hurts patient care and makes us less effective as professionals in the medical world. So I'm so grateful that these two parties have come together to find legislation so that we can have open conversations about events just such as that. And Mr. Chair, I would like to move the A2, and I believe council has some oral revisions to it as well.
Yeah, so members, although this went to HHS first, it was not heard there. It was withdrawn and re-referred here. So this is the first committee to hear the bill. The A2 would be in the nature of an author's amendment. Ms. Primo can identify for us the oral changes to the A2 before we take it up. Ms. Primo.
Mr. Chair and members, these are just technical changes. Line 1.12, after health, insert care. Line 1.14, delete of this. Line 1.15, delete section. Line 2.2, delete sunsets and insert expires.
All right, Senator Pappas will move the A2 amendment as an author's amendment. Senator Pappas, do you incorporate into that the changes suggested by council?
I'll do it, Mr. Chair.
Senator Pappas moves the A2 amendment as amended. Be adopted to Senate File 803. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Senator Klein, ready for your testifiers?
Please, Mr. Chair.
All right, I have David Renner from the Minnesota Medical Association first up.
Mr. Chair and members, my name is Dave Renner, representing the Minnesota Medical Association, and I'm glad to be here in support of this bill. We started working on this MMA over a year ago and having conversations with the Minnesota Association for Justice. And I've got to say, I believe in my 30-plus years of doing this, I believe this is the first time I've sat at the table with Mr. Carlson in support of legislation together. So we are glad we have been able to work that out. As Senator Klein said, we think this is mostly about patient safety, because this is really trying to encourage those conversations about what happened. We hear over and over again from injured parties that something happened and nobody talked to me, and the only way I could find any information was to file a lawsuit. So we believe in this situation, this will help encourage those conversations and hopefully avoid them from happening in the future. As Senator Klein said, this is a strictly voluntary process by all sides. Throughout the process, at any time, if an injured party believes that it's not going in the direction they want, they can they can pull out and still go through a litigation. But as Senator Klein said, in other states, we have not seen that happen in most cases. So once a injured party and a provider enters into this process, it does go more quickly, and it does result many times in compensation if that's warranted. So. Also, as Senator Klein said, we know of no opposition to this bill. We know of no fiscal note to this bill. This bill passed unanimously in the other body out of committee and is on the floor. So we strongly support and would encourage your support as well.
Mr. Carlson.
Good morning, Mr. Chair and members. Joel Carlson. I'm here on behalf of the Minnesota Association for Justice, and I would have liked to have been in the room to see Mr. Renner's jaw drop when I told him I'd love to talk to him about the Candor process. I had attended a conference with our executive director, Ms. Ferrucci, and we had a presentation on this process from Colorado and Oregon. And after talking to practitioners in a number of states, we came to the conclusion that if we could work something out that works for patients and protects their legal rights, that this is something that we want to encourage and support. And so we have worked for over a year to get this language. And Mr. Chairman, I'd like to at least direct members to the amendment so that you know the reasons why we have got to the point that we're at. First of all, on lines 1.3 to 1.8, several states only allow this to be doctor initiated. We wanted this to be both ways. The patient now, with that language, can initiate this process with a provider. We would like to talk to you about what happened. The provider doesn't have to do it, but the patient has a chance. Other states, Oregon has that, but Colorado doesn't. And so this, we think, was a big improvement of the law. We also were concerned that if you did get to a point where you had a resolution and they were going to make compensation, that there would be unintended consequences like subrogation interests. And we wanted, if they do get to a point of offering compensation, that we wanted the provider to encourage that they seek legal counsel and that they provide all of the billing information that they know. So you're not saying, oh, this is great, I've got a settlement, and then find out that all that money that you received just goes back to reimbursement for medical lien of some type. So that's an important part of this on 110 through 113. And the biggest, I think, and most important change for us is on 1.17 to 1.23. And I will call that provision the trust but verify section. We wanted a mechanism that would keep everybody honest, so that if you hear something in this Candor process and you don't reach a resolution, we want to be able to have the same story told if the patient does proceed to litigation. And so that section allows you to seek a court order outside the normal process of these conversations being confidential, but allows you to seek a court order to use that information to impeach the testimony if they tell you something different down the road. And we think that's a very important protection. And lastly, the sunset. If it doesn't work, we're going to come back and have a look at it. And so with those changes, we're willing to go down this path. We have heard from other practitioners that on a number of cases, this may be a quicker resolution and a quicker way for people to find out about their medical care, and we're willing to give it a chance. Thank you, Mr. Chair.
Any discussion from members of the committee? Senator Kroon.
Thank you, Mr. Chair. It seems like this is kind of consistent with the theory that, if in tort, if you make an improvement after the fact, that can't be held against you for making that improvement. And I think it's consistent with kind of like, don't let potential litigation get in the way of doing what's right. It's kind of in that vein is kind of how I'm seeing this. So I think this makes sense and appreciate the hard work that you all put into it. Thanks.
Senator Klein.
Thank you, Chair and Committee. I just want to thank my bipartisan authors, Senator Seeberger, Senator Frentz, and Senator Abler, and grateful for the consideration of the committee.
So apparently, members, this is an historic day. We have had testifiers invoke the Reagan doctrine of trust but verify. And I think forever now, this agreement will be known as the Capitol Accord. Where does this go? Senator Pappas? I was going to, since Senator Seeberger is a co-author, I was going to have her make the motion if she'd like to do that. And it goes to the floor. As amended.
Thank you, Mr. Chair. I'd recommend that this bill be recommended to pass and proceed to the floor.
As amended.
Senator Seeberger
amended.
moves that Senate File 803 as amended be recommended to pass and be sent to the Senate floor. All those in favor say aye. Aye. Opposed? Motion prevails.
Thank you. Thank you, Mr. Chairman.
Members, next item on the agenda is Senate File 893, Crime of Organized Retail Theft Establishment. As I'm the chief author, I will hand the gavel over to the committee vice chair, Senator Verbatim.
Senator Latz.
Madam Chair and members, there has been a concern for a number of years about a gap in the statutes that did not provide for a clearly identified criminal enterprise to be charged where what might otherwise look like small or isolated incidents of theft actually are a more coordinated and regular pattern of criminal activity. So in particular in retail crime. So a number of organizations, including what has become known as the Minnesota Organized Retail Crime Association, have been involved, the Retailers Association, the Chambers, and the law enforcement community as well. So this bill addresses that. We do have an author's amendment I'd like the committee to adopt, so I move the adoption of the A5 amendment.
Senator Latz moves the A5 amendment. It's an author's amendment. All those in favor say aye. Aye. Okay, the amendment's adopted.
Thank you. Madam Chair, the bill in its particulars or its key feature defines an organized retail theft enterprise, and you can see this on the A5 amendment, as an ongoing criminal enterprise having retail theft as one of its goals, in which two or more individuals participate. The term does not require the same individuals participate in each offense. And then it enhances penalties for that kind of organized, coordinated, ongoing conduct. We do have testifiers who I would like to have come forward and testify to the bill. Thank you.
Bruce Newstad, you can start your testimony by stating your full name and title for the record.
Thank you, Madam Chair and members of the committee. My name is Bruce Newstead. I'm with the Minnesota Retailers Association. We're a statewide collection of retailers, small, mid, and large size across the state. I really appreciate the opportunity to be here today and to chat about this issue. It's an issue actually we don't really like to talk about because it's a little bit of an ugly issue, but as Senator Latz said, there's a gap in our statutes, and we appreciate the committee taking a look at that today. I want to thank Chair Latz for authoring Senate File 893 and his leadership on this. I want to Senator Limmer for working on this issue strongly in the past as well. Deeply appreciated. Madam Chair, everyday retailers work in partnership with investigators and law enforcement. As Chair Latz mentioned, one of those organizations is called the Minnesota Organized Retail Crime Association that I serve as a board member on. Part of this bill was born out of a forum held at Metro State University several years ago talking about this very issue. Organized retail crime is, as it's called in the bill, organized retail theft, and unfortunately a common issue. It's a growing issue. It's over a $90 billion loss a year for retailers, but it also impacts consumers and communities. As Chair Latz mentioned, it's a problem that's unfortunately on the rise, not on the decline. ORC impacts retailers of all size, small, medium, and large. I think sometimes in the news we see the stories of the big retailers being victimized, but quite literally the issue is actually more impactful for a small retailer who cannot really bear those losses. So we appreciate Chair Latz bringing this issue forward. Madam Chair, just real quick on the small, mid, and large. I wish we had one of our testifiers here today. He was unfortunately to remain at work. There's a gentleman named Walter Dillon. Walter, about a year and a half ago, opened up a store in Little Canada, a sneaker store. And Walter kind of had one of these, if you build it, they will come mentalities. He talked his wife into investing all their savings into the store and fully immersed himself in it. And Walter was really lucky. He did build it and they came. Customers came. It actually revitalized a little bit of a shopping neighborhood in Little Canada. But unfortunately also the career criminals came as well. And they hit Walter 5 times in 6 months and took him out of business. His dream is gone. He's still recovering financially and quite frankly, he's still recovering emotionally from that. But we want to try to, as Chair Latz mentioned, alleviate kind of this gap in our laws today to address those types of crimes. Retail crime is different today than it was back in the 40s, 50s, and 60s. The syndicate and the mob doesn't look like it used to. Now it looks and functions different. And this law is really, this proposed law is really important to addressing that gap in the law. So Madam Chair, I'll end my testimony there, but happy to hang around for questions should the committee have any. But again, thank you, Chair Latz, for addressing this, and thanks to the committee for considering this law.
Thank you, Mr. Newstead. Committee members, questions or comments? Okay. Senator Latz, final comments. Would you like to, is this being laid over or are we moving the bill? Okay, it's being laid over. So any final comments?
No, thank you.
All right, the bill's laid over. I hand the gavel back to you.
Sitting there. Let's do that. Are you ready? Okay. All right, we'll take up Senate File 2659, Senator Seeberger dealing with fentanyl. Senator Seeberger, please describe your bill.
I believe I'm on Senate File 2216.
Sorry, my mistake. I didn't see your name next to that bill. You're here for Senator Mann.
I am.
Got it. All right, Senate File 2216 is before us on franchise agreements. Senator Seeberger, go ahead.
Thank you, Mr. Chair, members of the committee. 2216 would prohibit no-poach agreements between franchisees. A no-poach agreement is an agreement between employers that prevents franchisees from hiring away each other's employees, effectively limiting employees' job options. For example, many years ago, agreements precluded Jimmy John's franchisees from hiring each other's sandwich makers. So one employee could not go to work at the Jimmy John's across town without permission from their current employer. In 2016, it was estimated that approximately 60% of franchises had such agreements in place. What I find most troubling is that the employees whose mobility and job opportunity was restricted by these no-poach agreements never saw or signed them. but they could be turned away from a job because of them anyway. Mr. Chair, we talk about a free market, we talk about personal freedom. These restrictive franchise agreements are the exact opposite of that. This is evident by the fact that most franchises have now stopped doing these predatory practices, but not all of them. With that, I do have a testifier today, Mr. Evan Penman-Starr.
I understand Mr. Starr is appearing virtually here today. Mr. Starr, go ahead and unmute yourself and identify yourself, your affiliation, and proceed with your testimony.
Thank you so much for having me here. Can everybody hear me okay?
Yes, we can.
Thank you so much. My name is Evan Starr, and I am an associate professor at the University of Maryland. I'm an economist by training, and over the last decade, I've been studying the use and impacts of restrictions on employability, like no-poach agreements and non-compete clauses, and I've published more than a dozen studies on this topic. And broadly, the research supports regulating no-poach agreements in the ways addressed by this bill. And so I briefly want to summarize no-poach agreements and what some of this research has shown. So as was just noted, what are no-poach agreements? These are agreements between two organizations, or in this case, two franchisees of the same franchisor. So let me read you from the popular pizza franchise Sbarro. If you wanted to open up a Sbarro franchise, this is what you would have to agree to as part of the terms of your franchisee agreement. It reads, developer covenants that during the term, except as otherwise provided in writing by Sbarro, the developer shall not knowingly employ or seek to employ any person who is at the time employed or during the sixth-month period prior to such time was employed by Sbarro or by any licensee or developer of Sbarro. So what this means is that if you are a franchisee of Sbarro, that you cannot hire anybody who works at a current Sbarro or recently, within the last 6 months, worked at a current Sbarro. So in 2016, it came to light that many franchises were using no-poach agreements, franchises that you've all heard of, including companies like Amco Transmissions, Burger King, Buffalo Wild Wings, H&R Block, Sports Clips. And the thing is that employers tend to forge these agreements about workers' careers without workers at the table. Workers generally don't know that these things exist. And so it may seem, not that concerning for one of these franchise workers because maybe they can get a job, in some other company, some other industry. But the problem is that these collusive agreements take away exactly the jobs at which a worker is best suited. So think about a worker whose life changes for some reason, and they want to use their job experience to get a job in the same chain, but in a different location, right? Maybe it's closer to their kid's school or their aging parents' home, or maybe one location is just paying a few dollars more per hour. And when that worker applies for the job, the worker proudly lists their prior experience in that chain, hoping to signal relevant expertise, loyalty to the company. But given this agreement that the developer has, the developer takes that application and they promptly ignore it. They throw it in the garbage. And the worker has no idea why they didn't get the job. They just know they didn't get the job. And so the result is that franchisees do not have to compete with each other for talent in the labor market. So you might ask, what does this mean for workers? Well, after no-poach agreements like this came into our understanding, which was really in 2016, the Washington State Attorney General started cracking down on franchises that use them. And recent research revealed what happened here. And we find the research shows that workers' earnings grew 4% faster among those franchises that were forced to stop using these no-poach or no-hire agreements versus franchises that already did not use them. Okay, so what does that mean in dollar terms? The affected workers typically earned about $26,000 a year. These are relatively low-wage workers. And so what this means is that removing these agreements increased earnings by 4%, which is approximately $1,000 a year. There's a famous case you may have heard of on this issue, which is between Silicon Valley employers, Apple, Google, Intel, Adobe, many others. And they had a similar type of arrangement where they agreed not to hire from each other. And another piece of recent research suggests very similar findings, that just a single one of these agreements not to hire from each other reduced worker earnings, in that case, by about 2.5% per year. And so I think that it's worth talking about the rationale for some of these justifications. It seems clear from the evidence they seem to harm workers, but what are the supposed benefits of agreements like this, right? So advocates and they're not that many defenders of these types of restrictions, but what they'll say is, so we have trouble with retention already. Maybe we want to recoup our training investments in these workers. And I think that we should be very skeptical of these types of agreements or arguments. In general, there's just no reason to take away the best opportunity for a worker, the one that they are best suited for, without their knowing. These are organization level agreements. Workers are just not aware of them. So if a franchise wants to retain a worker, then raise pay, make the job better. And training, of course, is a two-way street. If an employer of a franchisee really has to hire somebody from outside the franchise, then they'll always have to invest in training. But if there's a trained worker out there who wants to leave their Sparrow or their franchise or their chain and wants to go work in another one, then the best fit for that worker is in another store within the same franchise. And it goes both ways. Sometimes a franchise owner may be the one who is the recipient of a trained employee. Sometimes they may be supplanted to others. In the extreme case, the franchise could offer a contract that offers training with a clawback provision that would say something like, we're going to invest this much money in you, and if you leave before 6 months, you have to pay a little bit back. And this at least would give the employee the opportunity to know what they're getting into. So to summarize, no-poach agreements like this, agreements not to hire from each other, they're already illegal under federal antitrust laws. But the franchise case has been a legal gray area. And so what this bill would do would close a loophole and bring the treatment of franchises into alignment with laws forbidding these types of inter-employer anti-competitive agreements generally. So thank you. I'm happy to answer any questions on the bill or this issue, broadly speaking.
Thank you, Professor Penniman-Starr. Are there any questions or comments from members of the committee? Not Senator Kroon. Wading in.
Thank you, Mr. Chair. I take it based on the effective date, and I want to make sure the amendment doesn't affect the intent as the effective date on the underlying bill, that this is only going to apply to franchise agreements that are entered into following the enactment of this bill into law.
Ms. Primo.
Mr. Chair and members, so looking at the A1 amendment that should be in the packets, lines 1.11 to 1.12 of the A1 amendment deletes the language at 2.22 and 2.23, which states that these apply to new or amended franchise agreements. So without the amendment, yes, it would apply to future agreements, but if the amendment is adopted, then Section 2 doesn't include that application clause.
Ms. Primo, for clarification, the bill itself directly deals with existing franchise agreements, right? So that additional language in the effective date really would undermine the main point of the bill. Would you read it that way? Ms. Primo.
Mr. Chair and members, yes, the provisions and the substantive provisions of the bill state that these provisions are prohibited. And then it's really sort of a policy choice in terms of which agreements are being affected, and that's in the bill that's addressed in the effective date. And, typically, I think some of these provisions that affect contractual provisions they clarify which agreements are specifically affected or not.
Senator Kroon.
Thank you, Mr. Chair. Well, I am looking at, in the original bill, lines 216 to 219, And it does seem to have an effect regardless of the effective date, that the intent of this is for franchisors to require them to change their existing franchise agreement within 1 year. So I guess I have a problem with the amendment and that language in the original bill. I just don't understand how we could force these changes on existing franchise agreements that people bargained for at the time, and creates perhaps some ex post facto issues here. I'm just thinking through this. I would be much more comfortable with this bill if it only applied to franchise agreements entered into after the effective date and didn't require the existing ones to go back and be changed.
Mr. Chair.
I heard a voice. I didn't see who said it. Senator Seeberger.
Thank you, Mr. Chair. I haven't offered the A1 amendment yet, but before I do, it seems to me if we were to amend the A1 amendment to strike lines 1.11 and 1.12, that might get at the root of the problem here.
So number one, I've asked Ms. Primo to look up how we handled the effective date for the non-compete bill. That was also Senator Mann's bill that came through here. But secondly, I'd actually be a little bit concerned about that, Senator Seeberger. I think if it only applied to new franchise agreements, then any existing franchise agreements would not be affected by the bill at all. So the Burger King, the Sbarro, all of those that the professor identified would not have to change their practices in any way. So it seems to me it would narrow the remedy down quite substantially from the purpose of the bill. I don't know if there's an ex post facto question here. That's one I'd be curious to have council address as well, but whether or not we have the authority to force a change in an existing franchise agreement in this nature. I suppose we could try and see what happens. That's another question, but that's a recurring theme in this committee. You know, Ms. Primo, any thoughts on this?
Mr. Chair and members, so I also have the answer to the non-compete agreement issue. So the effective date for Senate File 405 is effective the day following final enactment and applies to contracts and agreements entered into on or after that date. In terms of the contracts impairment issue, I mean, that's really a sort of a case-specific inquiry that the court makes. You know, you look at how substantial the impairment is in terms of the parties' rights and the ability to actually fulfill the terms of the agreement. And then you're looking, and if there is a substantial agreement, then you're looking at whether there's a legitimate interest that the legislature has in impairing that right. So it's hard to say whether this specific language is definitely an issue under our contracts impairment clause.
So I can see a distinction between the non-competes, which apply to individual employees and who are quite mobile if they choose to be so, and franchise agreements, which are typically much longer than maybe an employee may stay and less susceptible to change during the course of just in the normal process of business to be changed or amended until after they've expired or they're talking about renewing them. So it seems to me if the goal here is to have an impact immediately on employees, rather than waiting, if you're a Burger King employee, waiting until that franchise agreement ends in 3 years, then we'd have to not make the change of the amendment suggested by Senator Seeberger as an option. So I think it would be, personally, I think it'd be better to adopt the amendment, but without any amendments to it, to advance the purpose of the bill more directly. Senator Seeberger, what are your thoughts on it?
Thank you, Mr. Chair. I was prepared to offer the amendment without any changes, just trying to address the issues raised by Senator Cruen. As I sit here, I see both sides of the issue. I understand, the need behind this bill. Not being involved in most of the discussions leading up to this amendment, I'm inclined at this point to simply offer it as it is, and if there are further things we need to do, sort of address them as they come. So I guess at this point, I would move the A1 amendment as written.
So members, just so you understand, the intent is to move the bill back to the Labor Committee. So, FYI. Senator Cruen.
Thank you, Mr. Chair. I think I'm not going to pretend to be an expert in franchise law, and I didn't practice it, but it seems to me that franchise agreements don't go into perpetuity. They will expire on their own terms, I would imagine, and be renegotiated as part of a regular process. So while making this effective only on a going forward basis may not provide an immediate relief that you're talking about, it's not insignificant, because it will apply when these franchise agreements have to be renewed. Then this would kick in, and to any brand new franchise agreements. So I think there's two issues here. One is the legal issue about whether there's any ex post facto issues, and the second issue is whether, from a policy standpoint, we should be altering existing franchise agreements that parties have relied upon in making their business decisions and their investment decisions. That's my concern here, and I think on both the legal and the policy grounds, it would be good to be doing this on a going forward basis. So I don't know, I think the policy probably would be more within the purview of the other committee, and the legal would be within the purview of ours. Is that kind of how you see this?
I would say generally, yes, Senator Cruen, although there's probably some blended aspects to this because we're dealing with contract law as well. This did come from the Labor Committee, as I understand it as well. Let's see here. Yeah, it came from the Labor Committee, and we'll be going back there. There's one other thing to consider here, Senator Cruen, which is that one of the parties, perhaps the individuals most affected by this, are not the other franchisees, but it's the employees that end up being frozen in their current franchisee employment, unable to move to another franchisee anywhere in the country. So they're not parties to the agreement, but one might argue they're the most affected by it. And they may not have a year or two to wait. If a job opens up down the street, they wanted to work at Sbarro, they found the one 3 miles away, and the one right on their corner where they live has a job opening, that they'd be frozen out from taking that job, at least until the franchise agreement is renegotiated or renewed. Could be, in 6 months, it could be in 3 years, or however long the franchise agreements are. My guess is they tend to be multiple years, because if you get a franchise, you're making a substantial financial investment to open the store. And you pay a big franchise fee, typically, for that privilege. So my guess is they're multi-year agreements.
Mr. Chair,
Senator Kroon.
maybe Senate Council can help me out here. Is the employee provision here in question, are there any federal laws that apply that would make some of this illegal under federal law already?
Ms. Primo.
Mr. Chair and members, that's a little out of my purview. I can look it up and try to get an answer to you, unless maybe there's a testifier who might know the answer to that.
Professor Penniman Starr, do you happen to know the answer to the question? Is there any federal law that would affect this?
I'm not an expert on franchise law, so I'm not sure I'm the right person to ask here. I don't have a great answer for you.
Thank you.
Mr. Chair,
Senator Seeberger.
I think while we're looking to answer that question, I certainly don't know the answer to that question, but maybe I can add a little more perspective on this. And what you said, I think, really kind of gets at the heart of the issue here. These are the employees that didn't have any part in negotiating these contractual terms. I think it'd be a different story if we were looking to alter direct contractual rights that an employee had bargained with their employer. Then I think I'd be a little bit more hesitant to come in and say that from this day forward, then all these contracts have to be revised. But these are contractual provisions that are negotiated outside of the bargaining of the employee. And so I think as a legislature, I think we certainly do have that ability to state as a policy that we can't do that. And I think in terms of contract law, I think it's less troubling to have a pronouncement of policy and state that going forward, these types of provisions are impermissible when the person we're trying to protect was never a party to negotiating those terms in the first place.
Members, for what it's worth, I didn't phone a friend, but a friend just phoned me. Happens to be the representative of the Bar Association, who is their government relations person here, Brian Lake, who indicates he consulted with an expert franchise lawyer that he knows, who says that standard agreements are 10 years in length, but they can vary. That kind of answers the question for me. So, Senator Kroon.
Thank you, Mr. Chair. Of course, they would be at all sorts of varying points within that 10-year period. So some of them would be up immediately, 1 year, 2 years, et cetera, and it would be a more gradual implication. But given the kind of conversation, I appreciate the indulgence on this. I think it's an issue worthy of discussion. I'm not so sure what the legalities of it or what the courts might do with it. But perhaps if it is going back to the committee that has jurisdiction over the policy, they can wrangle with this issue there. And I'm concerned about this, but not to the point where I'm going to offer an amendment.
So, members, we have before us then the A1 amendment offered by Senator Seeberger to Senate File 2216. Seeing no further discussion, all those in favor say aye.
Aye.
Opposed? The motion prevails. The amendment is adopted. Now, is there any further discussion now on Senate File 2216 as amended? Not seeing any. Senator Seeberger moves that Senate File 2216 as amended be recommended to pass and be re-referred to the Senate Committee on Labor. All those in favor say aye.
Aye.
Opposed? Motion prevails. Don't go too far, Senator Seeberger, or pick up your other folder. Senate File 2659, fentanyl.
Thank you, Mr. Chair, members of the committee. It is my honor to be here before you on Senate File number 2659, which looks to increase the penalty for fentanyl sale, possession, relating to sale, and put it at the same level as heroin. Unfortunately, it seems that almost every day when you read the paper, there's another fatality due to fentanyl-laced drugs. This is an important issue that we must address this year. We need to stop the flow of this deadly drug into our communities, as well as ensure we are doing all we can to make our communities aware of the lethality of fentanyl. This is a poison. This is not just people taking fentanyl, knowing it's fentanyl. This is fentanyl that's being found in other substances that the user does not know is there. I am proud to represent the community of Hastings, who is, as a community, taking tremendous steps to increase awareness of fentanyl poisoning and the dangers. And you'll see my constituent Bridget Noring here, who has a very powerful story to tell. It's been a very emotional journey for her and for me on this bill. I'm really happy to be here presenting it. I will say that in addition to the stories that you are going to hear, I lost a nephew to fentanyl poisoning in 2020. His name is James. He was poisoned by fentanyl in a substance he didn't know it was in there. His brother, my other nephew, Garrett, found his body. So this is personal to me. I've been working in concert with our House counterparts to ensure that language addresses those that are dealing with this drug, but also account for those who may find themselves in harm's way due to drug addiction. I think the bill as amended strikes the right balance, and I am thankful for the work of stakeholders who have met all session to give input on this bill. I also appreciate the work that has been done before here in the Senate. I know this is a bipartisan effort, and I look forward to advancing this bill this year. I will say that I have had conversations. There's been a lot of back and forth on how do we set these amounts so that we get at the supply chain and the suppliers of this drug and not the users who may be struggling with an addiction use disorder. And I'm comfortable with the language in the A1. I know that the conversations continue, but this is an epidemic and we need to do something about it now. With that, I would like to open it up to my testifiers. I'd like Ms. Noring to go first. I know she's been waiting
Yes, we will
a
do
long
that.
time.
Thank you, Senator Seeberger. Ms. Noring, welcome to the Judiciary Committee of the Senate. I want you to go ahead and just identify yourself by name and proceed with your testimony, please.
Thank you, Mr. Chair and fellow members of the committee. My name is Bridget Noring. I am a resident of Hastings, Minnesota. I thank Senator Seeberger for presenting this bill today. April 4th, 2020, my oldest son, Devin Noring, was found by my youngest son, Caden, deceased in his bedroom. And we couldn't understand what had happened to him. Devin had been experiencing blackout migraines and dental pain in the months leading up to his passing. With the COVID lockdown, he was not able to get to, the vital appointments he needed were canceled. And that led him and his friend onto Snapchat, where they purchased what they believed was a Percocet from a known drug ring here in our community. That Percocet did not contain Percocet. It was 100% pure fentanyl, and my son was left alone to die. Over the last 3 years, I followed the two individuals allegedly responsible for my son's delivering the lethal dose of fentanyl to my son. I have sat in countless hours in court in various counties within the state of Minnesota, and I watched these individuals go in before the judges, tell the judges that they had a substance use disorder that they did not have, And as soon as they left the courthouse, they were back in their cars laughing at the leniency that they received. And then within minutes, posting back on Snapchat the lethal pills that they had available. With my written testimony, I did submit several screenshots of the pills that they were advertising on Snapchat. While our Dakota County Drug Task Force, along with our United Way of Hastings and Hastings Police Department, were raising awareness here in our community, they were still poisoning our community. We have lost so many good kids across this state. Department of Health, Minnesota Department of Health estimates that in 2021, 4 Minnesotans die every day. Majority of them are caused by fentanyl. That is one too many. And this is the third year in a row that I'm aware of that this bill has come before you. Our law enforcement needs this bill. I can't even tell you how many times I've watched these individuals go back out poisoning our kids. I'm so sorry. One of the alleged dealers in Devin's death, he lost his life to fentanyl a year after Devin. And that gives me no joy. That brings me no peace. That's another mother that had to bury her child. The other individual, he has now been indicted federally because the state laws are just not there to hold him accountable. There are so many stories of the same going through our state where these dealers are concerned. And these are poisonings. Majority of these individuals don't know what they are taking until it's too late. There's just this week, the DEA put out an alert about xylazine. Minnesota is one of 48 states on the list that have confirmed cases of xylazine. Xylazine is Narcan resistant. It's an animal tranquilizer. So without laws like Senate File 2659 in place, our children, our future is at an utter disadvantage. You know, our past legislators, they passed Minnesota 609.195 subdivision B. These are victims of third-degree murder. It doesn't matter if the intent was there or not to deliver these lethal doses. This is not about locking up those with substance use disorders. This is about getting these repeat serial killers off of our streets so our kids have a chance at life. Those who are struggling with substance use disorders have a chance at getting to recovery. So I ask that on behalf of the victims and our families across the state, you please pass this bill this year. Thank you for your time.
Thank you for your testimony, Ms. Noring, and we're very sorry for your loss, and thank you for your bravery in coming forward to share your story with us here today. We have Shane Myrie, and while you are testifying, if Abby Bryduck would come forward as well and take the other seat at the testifier table. Mr. Myrie, go ahead.
Thank you. Mr. Chair and members, my name is Shane Myrie. I'm a detective with the Hennepin County Sheriff's Office. I'm also the president of the Hennepin County Sheriff Deputies Association. I'm here this morning as a member of the Minnesota Police and Peace Officers Association, or MPPA Board of Directors, and we strongly support Senate File 2659 as amended. As the previous testimony demonstrates, fentanyl is here on the streets in Minnesota. It's on Main Street, it's on the side streets, it's in the back alleys, and it is lethal. According to a recent 2023 annual threat assessment of the U.S. intelligence community, transnational criminal organizations have flooded the U.S. with cheap, counterfeit pills containing fentanyl. Administrator Milligrom, who is the current administrator of the U.S. Drug Enforcement Agency, or DEA, has said fentanyl is the single deadliest drug threat our nation has ever encountered. And Dr. Raul Gupta, the director of President Biden's Office of National Drug Control Policy, testified to Congress in February that we must comprehend that the ground has shifted beneath us in relation to the drug supply environment. He further testified that the age of small volume, high potency synthetic drug production has clearly begun. Mr. Chair and members, fentanyl is a game changer. It's 50 times more potent than heroin, and we have not seen anything like this before in Minnesota. According to the Investigative Support Center, within the North Central High Intensity Drug Trafficking Area, or HIDTA, covering Minnesota and Wisconsin, we know that opioids, especially fentanyl, continue to pose the greatest threat, as a large percentage of overdose fatalities involve this class of drugs. We also know that fentanyl is produced primarily outside of Minnesota, or outside of the U.S., and it is sent and are transported to Minnesota, where it arrives in a variety of forms, including fentanyl powder and fentanyl-laced fake prescription medications like counterfeit oxycodone or Mbox pills or counterfeit Xanax pills. In 2020, a handful of narcotics task forces and drug interdiction teams in Hennepin County seized about 1,100 grams of fentanyl powder and nearly 3,500 fentanyl pills. In 2021, these same groups seized approximately 1,900 grams of fentanyl powder and nearly 35,000 fentanyl pills. In 2022, it was over 10,000 grams of fentanyl powder and over 630,000 fentanyl pills. And during the first 6 weeks of 2023 alone, these groups have already seized over 5,200 grams of fentanyl powder and nearly 160,000 fentanyl pills. In addition to the seizure numbers I just mentioned, the preliminary reporting in Hennepin County indicates that since the beginning of 2023, there have been over 500 suspected non-fatal overdoses and over 40 suspected overdose deaths. Statewide, our law enforcement partners are encountering the same trends and incidents in their local jurisdictions. In 2002, the Rochester Police Department seized nearly 80 pounds of powder fentanyl and nearly 40,000 fentanyl pills. Over the past few years, law enforcement in the St. Cloud area has seen increases in overdoses. In 2021, they had 60 overdoses. 38 were fentanyl related, 10 were fatal. In 2022, 73 ODs, 63 were fentanyl related, 13 were fatal. And in 2023, year to date, they've had 29 ODs, 24 were suspected to be fentanyl related, 6 overdose deaths, all fentanyl related. During a recent conversation I had with the night shift patrol supervisor with the Duluth Police Department, they said they encounter at least 1 overdose every shift. Our tribal police departments and partners are seeing similar trends. The Mille Lacs Tribal Police over the last 12 months has seized 17,000 fentanyl-laced counterfeit prescription pills, and they've responded to 56 overdoses and 7 overdose deaths. Recently, Red Lake tribal leaders met with U.S. Attorney Lugar to discuss fentanyl trafficking on the reservation. Mr. Chair and members, these are just a handful of examples of what law enforcement is seeing on the streets of Minnesota every day. In closing, in 2022, of the fentanyl-laced fake prescription pills recovered and analyzed by DEA laboratories nationwide, they estimate that 6 out of 10 have a potentially fatal dose of fentanyl. That's an increase from 4 out of 10 pills tested in 2021. To alert the public about these dangers, the DEA created a national campaign called One Pill Can Kill. Their message is simple. Never take a pill that wasn't prescribed to you. Never take a pill from a friend. Never take a pill you bought on social media. Just 1 pill is dangerous, and 1 pill can kill. I encourage everyone in this committee, room, and everybody watching online to review this information, discuss it with family members, friends, and associates. Mr. Chair and members, thank you.
Thank you, Mr. Maye. Appreciate your testimony. While Ms. Bryduck is testifying, if Nathan Benusa could come forward and take the other seat here. Appreciate that. Ms. Bryduck, welcome to the committee.
Thank you. Thank you, Mr. Chair, members. My name is Abby Bryduck, and I live in Minnetonka. Some of you may know me in my capacity as a transportation lobbyist, but today I'm here speaking to you as one who's gone through the trauma of losing a loved one to a fentanyl overdose. This is my sister, my beautiful sister, Tiffany Mahan, struggled with opioid addiction for several years before she was picked up by law enforcement in late December of 2020. She was referred to a Minnesota Adult and Teen Challenge and was thriving there. She had delivered a healthy baby named Harlow in August, and I was her birth coach. Right after Thanksgiving in 2021, Tiffany was close to achieving a year of recovery from addiction, adored her 3-month-old baby, and was just about to start cosmetology school. Tragically, she relapsed and bought some Percocet that was pressed with a lethal amount of fentanyl, which she consumed. She was 30 years old. My husband went to the sober house where she was living when her body was found to bring Harlow to our house for emergency care. Our family took care of him, and with my sister Colleen legally adopting him a few months ago. Incredibly, Harlow's birth father also lost his struggle with addiction, overdosed, and died 4 months after Tiffany did. The drug dealer who sold Tiffany the pills that killed her was informed of her death via a text the next day. His response was, "All in the game, yo." Those words were shocking, chilling, and infuriating to hear. My sister's life was not part of his game. Not only was that comment so callous, but it is so, so sad. The people who are stuck in this world have truly lost their humanity, and even death doesn't seem to faze them. That's why we need this legislation. I wonder how many other deaths that dealer is responsible for. I understand the inclination not to criminalize addiction, but honestly, Tiffany's drug-related arrests and incarceration probably prolonged her life more than once and allowed her to deliver a healthy baby. There's so many other Minnesota families who have stories like mine, and I hope you had the chance to view the Faces of Fentanyl display that was at the Capitol during February. This epidemic is taking young, vibrant, and hopeful people and crushing families along the way. I want to thank the committee for allowing me to testify, the County Attorneys Association and the MPPOA for their advocacy, and especially Senator Seeberger for her sponsorship of this important bill. Just an update. Harlow is 1.5 now, and he is thriving. He's a healthy baby, and we're so lucky to have him to remember her by. Thank you.
Thank you, Ms. Broderick, for your testimony. We're sorry for your loss and appreciate you coming here today to share your personal story. And looks like Carlo's very fortunate to have you in his life. We're going to turn now to our final testifier on this bill, Nathan Benusa. Go ahead, sir.
Thank you, Chair Latz, committee members. My name is Nathan Benusa. I'm Assistant County Attorney in Sherburne County. I'm speaking on behalf of the Minnesota County Attorneys Association today. We are in full support of this bill. Obviously, we've been working a number of years on trying to match the fentanyl thresholds with heroin. As many of you know, in 2016, there was a large overhaul to the drug possession laws. And what was separated heroin from the other ones was it was more illegal to possess it at a smaller amount considering its lethality and potency. So at this point, we believe fentanyl should also be done to match that. As we can see, it's up to 50 times more potent. As the Mr. Meyer testified to, it's been unforeseen what it's done into the communities. Overdose deaths are at all-time highs from this. From a prosecutor's standpoint, it's really exploded within the last 3 years, even from when we initially proposed this bill. Obviously, the most concerning thing we're seeing are these pill units when they're disguised as other pills and they're being distributed to community members. A large amount of the time, they're not knowing what's inside of these pills, and even the people who know what's inside of these pills, they don't know how much fentanyl is inside of them. So these pills are one of the largest concerns. That's why this newest amended bill addresses both powder form and dosage units, considering the explosion we've seen in these dosage units over the last 3 years. I think it's important to kind of give some real-life examples to show how hard it is to prosecute large-level distributors and dealers with these current threshold amounts. I'll give 2 examples. One example is we were following a drug distributor in Southeast St. Cloud for a while. We were doing controlled buys. We had a GPS unit on his vehicle where he was making weekly runs from Wilmer, so we knew that he had a distributor there. Then he was moving the pills to St. Cloud. Then we had a large number of controlled buys where he was doing 1 to 3 pills at a time. There was a search warrant executed at his house right after he had come back from that Wilmer location, and they found 600 pills. As you've heard, each one of these pills is potentially lethal. In this situation, we know he's likely just coming back from Wilmer, so we assumed at that point he's probably likely distributing 600 or so of these pills a week. Based on the weight of the pills, we were barely able to charge a first-degree sale for what we obviously consider someone who potentially killing someone every single day, and he's barely able to reach the first-degree sale thresholds. I wouldn't have been able to charge him a first-degree possession because I wouldn't have had enough of an amount of fentanyl to charge him with those crimes. In a similar situation, we stopped the person in a motor vehicle. He had about 300 pills in his possession because there was no indications that he was selling the pills through individual baggies or anything else that you would typically see when you have methamphetamine or heroin, where they're distributing them in smaller baggies or they have scales. We had nothing to connect them to a sale, so we had to charge a sole possession charge, which ended up being a third-degree possession because we weren't able to reach the second-degree possession thresholds. And this is a person who, like I said, and you've heard, each one of these pills is potentially lethal. He had in possession 300 of these pills, each one of them potentially lethal. It's pretty clear what he was intending to do with the pills, but to prove this to a jury beyond a reasonable doubt would have been extremely difficult. So he was charged with a third-degree possession case when likely should have been facing much more severe penalties. So kind of give you a street level what those pills may be worth. Metro, each one of these pills is likely $20. The further you get out state, the more expensive these pills are. So this person with $300 or 300 pills, that's likely at least $6,000 to $10,000 worth of these fentanyl pills. So it's hard to say that this man wasn't distributing them. And these are kind of the challenges we're facing as prosecutors with these current laws as they are, to be able to punish these high-level distributors and high-level dealers under the current framework. So now if I could point you to the specific bill itself, I think it would be easy for me to explain how this bill affects those issues we're seeing as prosecutors, how we would be able to put these lethal drug dealers and distributors, charge them with more severe offenses. So line 123, that's the previous statute that applied to heroin. They match up fentanyl in this situation and then add a sentence for dosage units. If you go further down to 126, that would be the old fentanyl, where fentanyl used to be under. As you can see there, for a first-degree sale, you would previously need 50 grams of fentanyl. For heroin, you would have needed 10 grams. So fentanyl is 50 times as potent as heroin, but you needed 5 times the amount of product to charge them with a first-degree sale. The new proposal is that would be down to 10 grams or 40 dosage units to charge a person with first-degree sale of fentanyl. As to possession, similar situation. Previously, you would need 50 grams. You would actually need 500 grams of fentanyl to charge them with a first-degree possession case, or you would need 25 grams of cocaine or methamphetamine, or you need, I misread that, sorry, you need 50 grams of cocaine or methamphetamine, or 25 grams of heroin. Now we match up fentanyl with the 25 grams of heroin, and once again, the potency is 50 times as amount, but in this situation, you would need 20 times as much product of heroin or 10 times as much methamphetamine or cocaine to match that with fentanyl. So we believe this will put those situations where we're running into someone with a high amount of these fentanyl pills or powder, be able to charge them with the appropriate first-degree possession case. And similarly, as we go through the bill, you'll see similar situations like this. In secondary sale, it was you need 3 times the amount of product. Secondary possession, you would need 8 times the amount of product as compared to heroin. And third-degree possession, you would need about 3 times as much product. In closing, I want to kind of stress what went through in making this bill as well. There are stakeholders. We met in the House committee and we met numerous times. The biggest thing that we wanted to focus on was not punishing users. So there's nothing in this bill that addresses fifth-degree possession that would further penalties for your drug users and those with addiction. And even as you'll see in line 5.8, out of concern that there wouldn't be a person that would be a typical user addict wouldn't get charged with a third-degree possession. This is the one section that actually deviates from the matching heroin and fentanyl, where you would need 3 grams of heroin, then make it 5 grams of fentanyl or 25 dosage units or more, so that it's clearly someone that would be within a likely dealer or distributor amount, and we wouldn't risk the potential that we'd be punishing users under that subdivision either. Finally, in closing, this would make our jobs as prosecutors easier to punish those who are risking the community at their highest. So on behalf of Minnesota County Association, we are in full support of this bill, and I urge you to pass this bill today. This would be a great step forward to helping eliminate these dealers and distributors and give them the appropriate penalty that they've been avoiding for a number of years now. Thank you.
Thank you, Mr. Benusa. I appreciate you going through the dosages. I'd noticed on line 4.17 the different ratio there for the second-degree possession than ratios that were present in other parts of the bill, and I was curious why that was. You said it's 8 times, a little over 8 times.
And I can tell you, the original part of the bill, it was distributed at a 4-to-1 ratio, and I can tell you that this second-degree possession part was part of a compromise in the House when they were making meetings about what each caucus would agree to. That was the distribution that they got to.
Thank you. Appreciate that insight. I don't have any other testifiers listed for this bill. Any questions? Senator Limmer.
Thank you, Mr. Chairman. Usually we don't talk about the actions in the other body, but in this case, I think it's vitally important. We had a bill that I authored, almost identical to yours, Senator Seeberger, with the exception of the A1 amendment. In conference committee, they refused to vote on that fentanyl bill. And as a result, I'm glad that we're moving the ball in the right direction. I'm glad the possession changes that they seem to accept is moving in the right direction. I'm just wondering, after repeated convictions, are the users even going to be alive to be prosecuted in the event that they have a larger quantity in their possession? But nevertheless, I'm glad that you're moving it. I'm glad that the House has maybe come partially to their senses. It was really quite staggering to think that they would vote against a fentanyl bill in conference committee, but nevertheless, conference committee was hung up on a couple other issues as well. But there was an exact vote during that time period over this issue. Senator Seeberger, would you allow me to be a co-author on your bill in the event that there would be room on the co-author spots?
Senator Seeberger.
Madam Chair, Senator Limmer, I would be honored to add you to this bill.
Thank you.
Members? Senator Seeberger, I just wanted to make a few comments too. First, I'm so sorry for your loss, and thank you for sharing your story. I apologize. I had to present a bill in another committee, so I missed most of the testimony. I believe we might have heard from some other folks who've been impacted by this, and we really want to get this right. This is taking folks' lives, and addiction is something that we continue to struggle with as a state. I, always have concerns about, with increased penalties, harming communities of color and criminalizing addiction. And I know you're working really hard to get that right amount. And I just hope that folks who are experts in harm reduction are part of this conversation, and wanted to just give you an opportunity to speak to how that conversation is going. What are some of those things that you're weighing to get this bill in the right place?
Thank you, Madam Chair. Members from Harm Reduction absolutely have been a part of the conversation. And this is an ongoing conversation. There have been a lot of discussions. There is we've had a fentanyl work group that's met Wednesday mornings. And I think nobody wants to penalize anybody with substance use disorder. That's not the intent of this bill at all. And the conversations have been surrounding, how do we get at those folks on Snapchat that are distributing these bills? And what's the right number? What's the right threshold? So much work has gone into that. And the language that we've landed on with this A1 amendment, we think is the workable number to get this bill out there. We can't wait any longer with the deaths. With the numbers that I heard just now are staggering. And I'd like to also say, as a paramedic, I see fentanyl in two different lights. I administer it therapeutically for pain. It's a narcotic that I carry on me and that I'm authorized to use when somebody is in pain. And fentanyl for pain is dosed in micrograms. So we talk about grams, it's not milligrams, it's smaller than milligrams. You got to move the decimal point 3 more spaces to get to a microgram. That's how I dose fentanyl. And my maximum dose for a person is 100 micrograms of fentanyl that I can dose therapeutically. When we're talking about grams of fentanyl, those are deadly doses. And so I therapeutically dose fentanyl in micrograms, but I deal with fentanyl as a paramedic, and that's where I administer Narcan. And I can recall a shift on the ambulance working in the North Metro. We carry a limited amount of supplies on our ambulance. If you run out, you got to go back to the garage and restock. It doesn't happen very often, or a supervisor will come out. One day we ran out of bag valve masks because it was overdose day. I administered so much Narcan and we used so many bag valve masks. Those are single use. I've never run out of bag valve masks on an ambulance before. We usually carry enough bag valve masks to have extra at the end of the shift. I ran out. We had to go get more. I've seen it. I think we all have a story or a way that we've been touched by fentanyl poisoning. I'm very sensitive to the needs of those in the throes of addiction and those with substance use disorder. And absolutely the conversation will continue so that we're not penalizing the wrong people. So I welcome to continue those conversations, but this bill needs to get out there now.
Thank you, Senator Seeberger. And this is, of course, part of a bigger approach, right, to this issue and to tackling addiction. You know, I know we heard a bill in education finance, and I can't remember who our chief author was, to supply Narcan in our schools, right, so that our kids who are struggling with addiction right now know that there's a trained professional there who's going to support them in a crisis. That's one piece of this as well. And I look forward to supporting all those efforts and continuing the conversation with you. Any other comments? Senator Limmer.
Thank you, Madam Chair. On the back page of the A1 amendment, we are mandating peace officers to carry opiate antagonist doses. How is that being paid for? Or is it a mandate to all law enforcement agencies across the state? And I'd be a little curious about the cost as well.
Mr. Turner, are you able to weigh in on that question?
Madam Chair, Senator Limmer, there is that provision in the back. It's mandated. I don't think there is a fiscal component to it. So in earlier conversations, again, on the House side, I think it's mandated for the local governments to do it. So from an NPPOA perspective, the rank and file members of law enforcement, we supported it and haven't had any objections to it. I can tell you the members of the task force that I'm on, we carry Narcan. Our agency, everybody carries multiple vials of Narcan with them. We actually had an incident a couple years ago. We were out doing surveillance on one criminal action, and we witnessed an overdose from a completely unrelated thing in the parking lot, and members of the task force used the Narcan that they had and treated the individual and called paramedics in and saved that individual's life. So we do it at the Hennepin County Sheriff's Office. Many folks carry multiple vials of it with us.
Thank you. And could you just state your name for the record? I didn't get a chance to introduce you.
Yep, Shane Myrie.
Thank you. Senator Limmer.
Madam Chair, we're not quite at the end of our budget policy development. We still have a little ways to go before the end of the session. I think as a committee and as we go toward the end of the session, we should try and figure out how we can help fund law enforcement. There's a lot of police departments that are not like the police departments in Hennepin County or anywhere else in the metropolitan area. The problem of fentanyl is all over the state. It's not a metro-focused problem. So with all the scads of surplus this state has collected over the taxpayers, you'd think that we could fund this and not put it on the backs of our cities and our law enforcement. So I hope to work with anyone to see if we can't squeeze out a little money for this. I think it's vitally important. Thank you.
Senator Seeberger.
Thank you, Madam Chair. Senator Limmer, I agree with you 100%. And I'd be happy to keep working on this to ensure that our law enforcement has the funds they need so that they can be supplied with the Narcan they need, because it's just so necessary right now.
Okay. Any final comments? Senator
Thank you, Madam
Seeberger?
Chair. Yes, members of the committee, again, it's my honor to be here. This is maybe one of the most important bills that I'm moving through this session. So much good can be done, I think, once we start. This is only the start. We've got a long way to go, but I'm honored to move that Senate File 2659 as amended be recommended to pass and referred to the floor. Where finance?
The bill's actually being laid over, Senator Seeberger.
Okay. Well, I'm happy to have said that, and so I look forward to it being laid over.
Thank you so much. The bill's laid over. Up next, we will invite Senator Kupak for Senate File 1459. Senator Kupak, when you're ready.
Thank you, Madam Chair, members of the committee. Senate File 1459 would require fuel retailers to report the number of intermediate blends, 15 to 50% of biofuel content. Fuel retailers who received a grant from the state to install equipment to offer higher blends in the past were required to report gallons for a 5-year period that has now come to an end. We have a really great story to tell in Minnesota about biofuels, but part of that ability to tell that story is to talk about how many biofuels we are still selling. So all reported data in the past was in aggregate form, but to ensure that individual station sales remain private information, it was requested by the Fuel Retailers Association that we added a non-public data language to make sure that data is protected. And because we amended that in Commerce, that sent us over here to your committee so that we could have that checked off by you. So I could rattle on a lot this afternoon or this morning about how great biofuels are and the great story we have, but I think I will just at the moment just keep it to those remarks because it's just this one little tiny thing at the end of Senate File 1459 that we are here for.
Thank you, Senator Kupak. I appreciate that. We have a long agenda ahead of us today. Members, questions, comments? Senator Limmer.
Thank you, Madam Chair. Senator Kopik, on the back page of the bill, lines 2.7, we're making the reports non-public data. Why would that be?
Senator Kupek.
Madam Chair, Senator Limmer, yeah, this was the part that we added in Commerce. And the reason we wanted to do that is we thought that they were concerned, some of the retailers, that if we gave this information out, it would be other competition could figure out how much gasoline they were selling, and they felt that it was data they didn't want to give. So we just want to know this would do individual stations, and we just want the big bulk number. That's all we're looking for.
Thank you.
Any final comments, Senator Kupek?
No, I would just appreciate your support.
Thank you. With that, Senator Westland moves that Senate File 1459 be recommended to pass and sent to the Senate floor. All those in favor say aye. Aye. Any opposed? Okay, the motion is adopted. Sent to the floor. Thanks, Senator Kupek.
Thank you, Madam Chair. I'm glad I could help speed this along today.
Senator Zhang, come on up. We have Senate File 1089 before us.
Hello, Chair and committee members. I have before you is Senate File 1089. It's a bill that is addressing auto insurance for underinsured and uninsured folks. As many of the committee members may already know, auto insurance is mandated by statute, Section 65B. These contracts should be subject to the state's contract statute of limitations in Section 541. Some insurers have been shortening consumer rights to auto insurance benefits by limiting the statute of limitations in these mandatory contracts, denying consumers the benefits they purchased. And so Senate File corrects that problem by saying auto contracts must adhere to the contract statute of limitations in Minnesota Statute 541. However, we've been working with both sides and trying to come to a compromise language. And you see here in Section B, we've come to 4 years from the date of accrual language. And so that's with both sides working together to come up with that proposal. And I have with me the testifiers, Mr. Carlson.
Thank you. You may begin. Please state your full name and title for the record.
Thank you, Madam Chair and members. I'm Joel Carlson. I own a legal research and government affairs business here in St. Paul. I'm here on behalf of the Minnesota Association for Justice. And with me is the president of our association, Chuck Slain. And we just want to create a record because it's important that we make sure that things that are in place right now are not disturbed by the language that's in front of you. There's a split in the courts, Madam Chair and members, as to when a cause of action for underinsured motorist claims accrue. And in working with the Insurance Federation, we want to make sure that the consumers get the benefit of the statute of limitations in 541, which is 6 years from the date of an accident. But there's been a developing trend with some insurers that have been inserting contractual statute of limitations that are shorter than what the law provides. That has created a problem for some consumers because under a Minnesota court decision dating back to 2000, you couldn't file your underinsured motorist claim until it was ripe, meaning you had settled with the underlying liability carrier. So this corrects that problem, but it does not disturb the accrual date, which is the date that you settle with the at-fault driver. And it also doesn't disturb the notice that is required under a decision called Schmidt, so that if you're going to settle, you have to give your insurance carrier notice of that so that they can intervene at that time. That's what the bill does, and it corrects a disparity in the courts and an unintended problem. And I'll have Mr. Slain speak to the bill, and then we'd be happy to answer questions.
Thank you, Mr. Sling. If you could start your testimony with your full name and title.
Thank you. Chairwoman and members of the committee, my name is Chuck Slane. I am a lawyer in Minnesota and the president of the Minnesota Association of Justice. This bill has been a compromise between the stakeholders. We have worked together and made sure that the safeguards that are currently in place in the law remain, with accrual and the time limits. Statutes of limitations are about certainty for both parties. It's important to know how much time do we have and when does the clock begin to tick. And this bill will solidify those things so that they can't change the rules in the policy of insurance, which most people will never read. And we're happy to have also reached a compromise on providing a shorter statute of limitation on the underinsured motorists to accommodate the interests of other stakeholders. And with that, we urge the committee to support the bill and pass it.
Thank you, Mr. Sling. Committee members. Senator Limmer.
Madam Chair, is there anyone from the insurance industry that wishes to make comment?
Come forward.
I haven't seen the whites of his eyes today, so.
Don't shoot.
And please begin your testimony by stating your full name and title for the record.
Yes, Madam Chair, members of the committee, Aaron Cocking with the Insurance Federation of Minnesota. Just coming in, I see that was up. We're in agreement largely with the proponents of this bill. We had some issues. We would have rather had the statute of limitations been set at 2 years. We feel we're giving up some of our contractual rights that we had put in our contracts before, but by and large, I think the assertion that this is an agreement is generally accurate.
Thank you. Okay. Seeing no more comments, Senator Seeberger moves that Senate File 1089 be recommended to pass and re-referred to the Commerce Committee. Just before I take that, Senator Zhang, did you have any final comments? And we'll go to Mr. Carlson.
Madam Chair, members, we appreciate Senator Zhang carrying this bill on behalf of the association and working with us, but we've already been to Congress. I think we go to the floor.
Yeah. And the Commerce Committee needs this to put it in their omnibus, so it's being sent back there.
You're the boss.
That's right. Senator Zhang, final comments, and then we'll take a vote on the bill.
I urge your support. Thank you so much.
All right, we've got the motion on the table for Senate File 1089 to be recommended to pass and be referred to the Commerce Committee. All those in favor say aye. Aye. Any opposed? The motion's adopted. Thank you, Senator Zhang.
Thank you.
Senator Kunesh, come on forward. We've got Senate File 60. You ready? Yes, Senator Kunesh, whenever you're ready.
Okay, so Senate File 60 is a request. There's 3 lines at the end of the original bill that it would allow tribal nations let's see here, it would allow tribal nations to have private educational data shared with them, and it is an effort to be able to support our Native students through their tribal entities and support their need perhaps for funding, for mentorship, or for any kind of support services that the tribes might be able to provide for them.
Thank you, Senator Kunesh. Members? Senator Limmer.
Thank you. Senator Kunesh, I remember we discussed this a year or two back, and I think that the debate raised a question about the rights of a parent to advance data on their student versus a tribal community. I don't remember the whole discussion, but does this, if a tribal community wanted to, let's see, what tribal
Madam
share
Chair.
information, does that violate any kind of parental authority?
Senator Kunesh.
Sure, and I'm sorry, I should have mentioned that I have a testifier here. Lori Harper is online, and maybe she could do a little explanation. And then, Lori, did you hear that question?
Yes, I did.
If
you could maybe address that in your response as well.
Okay, we'll go to you, Lori Harper. If you could, looks like you're unmuted already. State your full name and title for the record as you begin your testimony.
Maye Quade. Good morning, Madam Chair and Ranking Member, Minority Member Limmer, members of the committee. Anine, and good morning. I am Lori Harper, Director of Education for the Leech Lake Band of Ojibwe and a tribally appointed member of the Tribal Nations Education Committee. The body named in Minnesota State Statutes 124.73 and 136A.032. Miigwech and thank you for listening to me today regarding Senate File 60. Tribal nations are charged with the health and prosperity of our children, families, and communities. In order for tribal nations to positively impact the state's identified educational achievements, adopting Senate File 60 only makes sense. For tribal nations to have access to data regarding our children and students, it will better inform our services, programming, practices, and policies that will better support our partnerships with local educational agencies. In 2015, Every Student Succeeds Act, ESSA, was passed. It was passed to replace the No Child Left Behind. With the passage of the 2015 ESSA, it ushered in a new era for tribal nations to be consulted with on the education of our children. 2016 saw tribal nations, our tribal educational agencies and departments, developing consultative policies in partnership with the Minnesota Department of Education. In 2019, the LEAs, or public schools superintendents, reacted to Minnesota Department of Education's guidance in regards to ESSA and refused to share American Indian student data with Tribal Nations Education Committee and tribal nations. When data was shared with tribes and TNEC, the American Indian student information was suppressed and included with other student demographic information. For tribes to be included with the various other entities identified in the current law for data practices, Senate File 60 will be greatly appreciated by the tribes and the Tribal Nations Education Committee. Miigwech Bizendawiyik. Thank you.
Thank you, Ms. Harper.
I'm sorry, and did that answer your question, Senator Limmer? You might need to repeat it.
Thanks, Senator Kunesh. Senator Limmer?
Yeah, thank you, Madam Chair. Senator Kunesh, I'm reading a little higher up on the page, starting on line 3.12 or 312.
Mm-hmm.
And it makes a little bit more reference to the inclusion of a parent. However, the one word on 320 or going up to 319 at minimum, institution must distribute information release forms at parent-student orientation meetings, or so they could exclude the information release form and only deal with tribal nations about tribally enrolled or descendant students to the extent necessary to support educational attainment of the student. So it looks like it's streamlining the information. I guess the or is the one thing that could exclude a parent. Am I reading that correctly?
Madam Chair?
Senator Kunesh.
You are reading that correctly, but I believe, and this is what was explained to me, that under the federal data sharing laws, that it is still covered under, that parental permission is still covered under that.
Madam Chair,
Senator Lemmer.
I remember we had this discussion a while back, and at that time, I think I realized that it was okay for me to support. I'm just trying to jog my memory a little bit.
Madam Chair.
Senator Kunesh.
I do believe you were in support of this, and this was maybe 2 or 3 years ago, and omnibuses didn't get passed, and this is, yeah, we're bringing back some old unfinished work.
All right, thank you.
Okay. Senator Kunesh, it's my understanding this will go to Education Finance, your committee. Wonderful. Any final comments before we move the bill?
Nope, I just appreciate you listening to it and moving it along so that we can finish this unfinished business.
Wonderful. With that, Senator Westland moves that Senate File 60 be recommended to pass and re-referred to the Education Finance Committee. All those in favor say aye. Aye. Any opposed? Okay, the motion's adopted.
Thank you.
Thank you, Senator Kunesh. We will move to Senate File 1921. Senator Westland. Whenever you're ready, Senator Westland.
Thank you, Madam Chair. I am presenting Senate File 1921, and I do have an A1 amendment.
Okay. There we go. Senator Westland, this is the first stop, author's
Yes.
amendment. All right, Senator Westland moves adoption of the A1 amendment. All those in favor say aye.
Aye.
Any opposed? Okay, the amendment is adopted.
Great, thank you so much. This is a bill that deals with discharge plans for folks coming out of our jails. And statistics show that people with mental illnesses are more likely to end up in jail than the general population. Minnesota sheriffs and jail administrators will tell you the same thing. We need more support to keep people out of jail, to help people in jail, and then, of course, and perhaps most importantly, to support them when they leave jail. So this bill is designed to help break down the barriers for people getting the support they need. Many people would benefit from being able to talk to a case manager to make sure they can get the medications when they leave jail, and also to find peer support. According to the Prison Policy Institute, the average price for a 15-minute call in a Minnesota jail is $3. This is an average. We know a common price is 50 cents a minute, so making a 20-minute phone call is $10. Many people in jail have very little access to financial resources. The burden then falls on their loved ones or mental health providers to cover that cost. And so we don't want to make people choose between support from their loved ones and support from a provider. This does not mean that people will be receiving therapy through these calls, but these calls would focus on coordination and support. In addition to helping people while they are in jail, this bill focuses on the reentry and discharge planning process in particular. It requires the DOC to update and expand a model discharge plan for all jails in the state. It doesn't create a mandate, but it does provide jails with best practices to follow and to support folks who are leaving our jails. And then lastly, the bill does provide grants for many of the counties that have specific staff working in their jails to coordinate these services and support. The funding could also be used to allow other counties to pilot their own reentry services. The funding is targeted especially for meeting some of the material needs of people leaving jail, including help getting IDs, transportation, clothing, and food in some cases. The hours, days, and weeks after being released from jail are extremely vulnerable times for folks. And this bill would seek to provide that support so that people are re-entering the community in a way that is safe for them, for the community, and also to avoid issues with recidivism. And Madam Chair, I do have two testifiers, and we will start with Mr. Boutte.
Mr. Boutte, if you could begin by stating your full name and title for the record.
Thank you, Chairwoman Brayton. My name is Elliot Boutte. I'm the Senior Policy Coordinator at NAMI, Minnesota, the National Alliance on Mental Illness. I'm also speaking today on behalf of the Mental Health Legislative Network. It's a coalition of over 40 mental health organizations, and the network has worked on a number of bills this session, and this is our criminal justice proposal. So it's built off of a bill from last session, which was just the piece that requires free phone calls from the mental health providers or case managers. It also includes free calls to insurance navigators, which is really important for people transitioning back to the community. And I also want to highlight that the Minnesota Warm Line is included, which is a peer support line. And we know that our jails are struggling to care for people, and I do believe that talking to a peer specialist could really make a difference for some people in jail whose mental health may be struggling, and we don't often have the hours or the time for, licensed professionals to be in, but if a person can have free access to a peer support specialist, then I think that could really support people. I'll rewind to the first section of the bill, which has to do with the Hardell-Sherrill Act, which was passed in 2021. And that act requires new and needed standards for mental health and health care in the jails as part of the administrative rules. And NAMI's been a part of a working group that is working to draft those. And that law requires the DOC to post license infractions on their website for jails. And it was really just a small drafting error that the lowest level of infractions, which are correction orders, were not included. And these are rare, but we did ask the department for an example, and one that was, that they told us was a facility being cited for well-being checks. And that is actually, a pretty significant reason why some families experience tragedies like Hardell-Sherrill's family. So this is just a measure for more accountability and transparency. The third section of the bill requires an update to a model discharge plan by the Department of Corrections. Like Senator Westland said, it doesn't create any new mandates, but just kind of best practices. There's a small change in subdivision 2 of the third section, which ensures that people with the most serious mental illnesses are really getting special attention when they transition back to the community. It's already a requirement, but this section of statute is almost 20 years old, and we're not sure if counties are following it, not out of any bad intent, but simply because they might not be aware of the law. And we have a couple other testifiers which can speak personally to the importance of the law. I did want to highlight the work of Hannah Jarabek from McLeod County Human Services, who has gathered the contact information for all the different jail social workers and programs in the state and has held monthly meetings to coordinate and bounce ideas on off of each other. And the funding in this bill would go to positions like hers. And I just think it's noteworthy that over 30 counties have these types of programs and positions working with incarcerated people, and that's simply because those communities have seen the need and responded. So thank you for hearing this bill. We urge your support so that these communities can continue and expand this work.
Thank you, Mr. Boutte. Brandon Stolt. If you could begin your testimony by stating your full name and title.
All right. Thank you, Chair and members of the Senate. My name is Brandon Stolt, and I live here in the city of St. Peter, here in Minnesota. Thank you for the opportunity to speak on Senate File Number 1921. I was incarcerated in jail one time back in 2018 and 2020. The first time I was taken to jail, I did not have access to any medications for the first 5 days I was there. This made the already stressful situation even harder, and mental health got worse. My case manager was one of the most supportive people in my life when I was sentenced to 23 days in jail in 2020. I was fortunate to be able to prepare and have some money when I went in. I knew I would need visits from my caseworker to feel supported. My case manager was able to communicate with my therapist so I wouldn't get in any trouble for missing court-ordered therapy. They're also able to communicate with my parents, legal guardians, and let them know how I was doing. When my caseworker met with me, I was also able to share my concerns and know that someone was listening to me. To set those meetings up, I had to call my case manager, and that cost 50 cents a minute. When you're talking on the phone, time moves fast. For a 20-minute call, I had to pay $10. I couldn't afford to talk with other supportive people like my family and loved ones. There are also other things that cost money in jail, like seeing the nurse or if you need medications. I was also fortunate to be able to talk to my case manager, but I know a lot of people in jail nowadays don't have any money, and a lot of people nowadays also stay in jail a lot longer than I did. Some of those people may have to choose between seeing the nurse, having medications, or contacting their caseworkers or therapists. I hope that you will pass this bill to make it easier to access support for people who might be struggling with their mental health. One more thing I want to add is that our justice system in Minnesota needs to be better, as Elliot kind of explained, because more people nowadays need more mental health supports, financial support in the county jails and state prisons, because people are suffering. They're getting mistreated, abused emotionally, mentally, physically, and the jail staff just does not care, and that all needs to stop. It's been ongoing for forever, and it doesn't seem to change. And if this bill gets passed, that'll definitely make a big difference, because law enforcement officers need to be able to help people in mental health crisis situations and things like that, and most officers aren't trained in that field, so that's something also that needs to be also done and stuff. And people that go to jail, yes, have to be punished for their crimes, but I've had so many loved ones and everything, people that I've known throughout the years that have suffered in jail and stuff, and even when they weren't guilty of anything, they completely suffered, and that all needs to change, and things will be a lot better. Thank you.
Thank you, Mr. Stolt, for being here today and sharing your story with us. We have one more testifier joining us virtually, Hannah Jarabek.
Yes, thank you.
Hopefully I'm pronouncing your name correctly. You can unmute, state your full name and title for the record as you begin.
Thank you for the opportunity to testify this morning. My name is Hannah Jarabek, and I'm a licensed social worker with McLeod County Health and Human Services and the McLeod County Jail. About 4 years ago, we incorporated this free entry program into our jail. This need was identified by our jail nursing staff and our jail administrator, who were becoming overwhelmed with inmates requesting resources for their basic needs, such as housing, medical insurance, assistance to pay bills, and of course, many others. Currently, our jail contracts with Health and Human Services to have this reentry program on a very part-time basis. The current contract is about 12 hours a week, which just isn't enough. Because this isn't a full-time program, I'm also a case manager being pulled in many different directions, and I can't always assist our inmates in a timely manner. I do assist our inmates with a variety of needs, such as chemical use assessments and treatment coordination, MNsure applications, SNAP food assistance, GA, cash assistance programs, as well as housing and transportation resources, and a variety of others upon their release. Our program is voluntary and the inmate has the choice to meet with me, and I try to help with resources even if they don't live in our county. McLeod County is a fairly rural county, and resources can be hard to come by. So I do try to assist our inmates to make those connections while still incarcerated to help break down those barriers they may face upon release. With limited time to work in the jail, it's challenging to meet with every inmate to make an impact. If there would be funding for these programs in every jail in the state of Minnesota, we could have more full-time positions dedicated to making an impact with our justice-involved population, including adults and juveniles, to again break down barriers and bring more mental health supports in our jail. Mental health continues to be a challenge for this population. Sometimes I hear from others, well, people are safe and sober in jail, and that couldn't be further from the truth. Our jails seem to be the place that people come to, not only when offense is committed, but even when someone may be in the hospital or an inpatient mental health stay and the hospital just can't meet their needs or handle them. They then come to our jails. Not to mention when somebody is in jail and needing medications for physical and or mental health needs, they have to pay for them because medical assistance insurance isn't active while they're incarcerated. Many come into custody and don't have any funds, and when they realize that they will be billed for their medications, they simply choose not to. It's disruptive to people when they can't stay on or even start medications because oftentimes this is the first medical professional they've seen in a while. When people leave our jails and they are homeless and struggle to find resources, getting them back on health insurance and any program proves to be extremely challenging and creates a huge barrier, which is why we often see them come back to us. With more resources to work with people while in custody, jails could send inmates back to the community with medications in hand and secure connections to treatment and other positive resources in the community. Please consider funding this bill. Thank you.
Thank you, Mr. Chair. We don't have any other further testifiers.
Thank you for your testimony, ma'am. Is there any committee discussion then on Senate File 1921? Senator Umer Verbatim.
Thank you, Mr. Chair, and thank you, Senator Westland, for bringing forward this bill. This is an issue that I'm very passionate about as well, and think this is a bare minimum that folks have the cost of these mental health service-related calls covered. I'm really proud that our Department of Corrections included the funds in their budget this year to cover the cost of all calls from prison. It's really been a predatory practice to ask our folks to cover those costs. It can be upwards of like hundreds of dollars a month just to spend that time talking to your family. And that is so key to reducing recidivism and making sure that folks, can re-enter our communities. So I would love to see all of the cost of all these calls covered, and we got a bill in a little bit later in session that does have some of that policy language, so I'll talk to you about getting on there. This is being laid over. I think we have time to amend that and see what we have the funds for, but certainly we're on track for corrections and are in conversation with the counties about their jails. So thank you so much for bringing this forward, and I hope that we can work together in making sure folks can contact their loved ones and contact the professionals that they need.
Any further committee discussion? All right, members, Senate File 1921 as amended is laid over for possible inclusion in the budget bill. Members, we are now going to take up Senate File 2059. Senator Frentz is the chief author. I'm going to stand in for him today in the presentation. So, Senator, move verbatim. We'll come back to the gavel.
Senator Latz.
Thank you, Madam Chair and members. Senate File 2059 is a biannual appropriation that we give to the Minnesota County Attorney's Office to train their prosecuting attorneys in how to be effective and better prosecutors. Because of the increased demands of their job, they are asking for an increase of $100,000 per year for a total of $200,000 per year. Their typical training year includes 40 classes, webinars, and on-demand events, including they maintained that process during the pandemic as much as they possibly could, including virtual conferences and expanding the number of on-demand sessions that were available. They also have trial school, which is a very expensive one to do because it includes a 1-to-1 ratio of faculty to students, travel time, time out of the office, and audiovisual equipment. Because there is also an enormous increase in retirements and a lack of seasoned applicants, there is a greater need for training attorneys on new attorney topics. They've also, the County Attorneys Association has also experienced a reduction of seasoned faculty, so they have trained the trainer courses that they also need to increase the availability of experienced faculty. We do have with us a testifier, president of the Minnesota County Attorneys Association, Nicollet County Attorney Michelle Fisher. I'd ask you to hear from.
Thank you, Senator Latz. Michelle Fisher joining us virtually. You can unmute. Please state your full name and title for the record as you begin.
Thank you, Madam Chair and members of the committee. My name is Michelle Zunder-Fisher. I'm the Nicollet County Attorney and, as indicated, the president of the Minnesota County Attorneys Association. And I want to thank the committee for allowing me to appear today and to appear virtually before you. There are 87 elected county attorneys and roughly 800 assistant county attorneys in Minnesota. These attorneys are responsible for prosecuting cases, representing counties and county agencies, and protecting the most vulnerable of our communities in cases pursued through child protection, adult protection, and civil commitment actions. A county attorney's office is the equivalent to a general practice law firm. To do that work, we need training and education on the diverse and sometimes very esoteric issues that seem to arise on a daily basis. The need for training not only includes the legal work we handle, but also includes information and education about the conditions that lead to the individual and the family involvement with the legal system. This includes understanding chemical dependency, mental health challenges, and child welfare issues. Many of the county attorneys and assistant county attorneys are from small offices with small budgets for training. These offices have 3 to 4 attorneys total. These are some of the offices that are in need of most training opportunities. All county attorneys' offices are responsible for the same work regardless of size. While metro counties may have the ability to have one person responsible for one area of law, such as tax law, civil litigation, commitments, child protection, and criminal prosecution, most offices, like my own, have one person responsible for multiple areas of law. To do our work well, to serve those in our communities, and to do justice, we need training. For county attorneys and assistant county attorneys, the availability of relevant continuing education programming is limited, as most continuing education is geared toward criminal defense attorneys, and the availability of training on the other issues we handled is limited to non-existent. Therefore, as an association, we need to provide the training for our members. This training bill would allow MCAA to increase training opportunities, especially for experiential learning opportunities. As mentioned, the pandemic greatly interfered with our on-the-job training that is integral to county attorneys' offices. The ability to have new attorneys sit at council table and watch experienced attorneys handle cases, to handling those cases themselves with that experienced attorney sitting next to them offering feedback, and to participate in our trial school. It also greatly hampered law school training opportunities in motion practice and trial advocacy. Those skills were taught and practiced via Zoom. When I think back to my mock trial competition days, I remember having to get up at 8 o'clock on a Saturday morning and put my suit on because our coaches always said you have to play the role to do the role. Court training is no different, and those opportunities are vital to effective skill development and justice. The bill under consideration would increase MCA funding for vital training. I'm proud of the training work that has been done by MCAA with our very strong staff and largely volunteer faculty. We generally do not pay our faculty, relying on talent within the association and affiliated organizations. The increased need for training is compounded by the increased cost of that training in lodging, technology, and other costs. During the pandemic, we were able to pivot to continuing some training and a few conferences virtually. We were not able to continue the valuable skills training at the trial school and other in-person training. This same period saw a large number of retirements and a loss of attorneys with significant experience. Our trial school is highly sought after training opportunity. It gives lawyers opportunities to do the trial skill and then get immediate feedback on substance and style. It was absent for 2 years, and as I referenced, there was an even greater demand because of so many new lawyers coming into the practice. Tied to this trial school is the need for trial school instructors. With the retirements and turnovers, we need to develop strong trainers by offering train-the-trainer events. Again, we are fortunate to rely on the volunteer faculty, but still have significant expenses for venue, meals, mileage, and lodging for these instructors. This training money would allow us to increase offering of those skills courses. In addition to our trial school, MCAA offers robust training that takes place over noon hours or day-long trainings targeted at specific topics. Hot topics include new legislation, understanding the use of technology in criminal cases, the Rule 20 and GAP case changes, and data practices. This funding will allow the association to ensure that county attorneys' offices receive timely, vital, and necessary training for the diverse topics that we deal with each day. A fair and just system requires that all parts of that system receive proper training. We submitted, and you should have before you a one-page, which actually is like a 3-page highlights of what the association does. And I refer you to that document for specifics, and I would be happy to answer any questions that you might have. Thank you for taking for this opportunity to appear before you, and I would urge your support for this file. Thank you.
Thank you, Ms. Senator Fisher. I just have one question. Is the total cost $100,000? Or is that being added on to an additional cost that existed elsewhere? Senator Latz.
Madam Chair, there is a base already, and the appropriations will be added to the base. I can ask Mr. Turner to explain that more specifically.
Mr. Turner.
Madam Chair, Senator Latz, I believe this is...
Pull the mic down.
Madam Chair, Senator Latz, I don't think there's a base for this. I think this is something that that we annually or biannually appropriate, although it looks like Nancy Haas might have the answer.
Maybe it feels like a base.
Nancy Haas, if you could state your full name and title for the record when you begin.
Madam Chair and committee members, my name is Nancy Haas. I'm a lawyer and lobbyist with Pohl Haas, and I'm representing the Minnesota County Attorneys Association. There is a $100,000 current base appropriation in the Office of Justice Programs. You might recall we moved that over from the Attorney General's office many years ago. So there's an existing $100,000 in the Office of Justice Programs, and so this would be an additional $100,000.
Thank you, Ms. Haas. Okay, seeing no other questions, any final comments before we lay the bill over?
No.
The bill's laid over. Thank you, Senator Latz. We'll move to your next bill, Senate File 2396. Whenever you're ready, Senator Latz.
Madam Chair and members, Senate File 2396 is a request from the private detectives to add to their certification process that will facilitate, make it administratively easier for detectives to provide proof that they're properly certified.
Thank you, Senator Latz. Any questions? Okay. With seeing no further questions, the bill is laid over for possible inclusion in the omnibus. I think it's time for us to take a break.
Nothing else that I can do that quickly?
According to our staff, no. So, what time? Okay, we're going to recess until 1:30 p.m. Committee's in recess.